This is transfer matter, my lord. The petitioner sees attached in the DRC office of Calcutta.
Tomorrow.
My lord, there is RSC, my lord.
Tomorrow. When you have been released? No.
No, not yet. But
Transfer has to be effected when it was passed.
it was passed on 24th of last month. I
Tomorrow.
have submitted my representation on 2nd, but till that I have not yet been released. But today it's been Monday, my lord. The authority might release me, my lord.
8-2.
8-2, my lord.
May I, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 19, Your Lordship.
19.
Yes, here we have to obtain instruction and for filing counter affidavit. At least 3 weeks time may be given, Your Lordship.
Who is for petitioner?
I,
No issue.
no objection.
No objection.
Yes.
On the prayer of MSP Pango, Learned State Council, come on. List this matter after 3 weeks so as to enable her to file counter affidavit.
Oblige, Your Lordship.
Your Lordship, I beg to mention item number 10. I am from the petitioner, respondent side, private respondent number 6. I'm from the respondent side, private respondent number 6. I'm here mentioning on behalf of my leading senior, Titi Tara. He's out of station, so matter may be fixed on.
No, yes, Tari might have completed by now. Works might have completed.
Most have been completed.
Become in process.
The matter may be fixed on 30th, my lord. So that's
Matter has become in process. We'll
Council-
deposit of as in process.
Your Lordship,
yes, it can be disposed of
As in process.
in practice. But
Ah.
that part not from my submission, my lord. Let the standing council be submitted.
No, this is you are the petitioner.
I'm the petitioner, yes, my lord.
This is you
As-
have to
as per
submit.
instructions of the petitioner, they said this work is for the 5 years for including maintenance, my lord.
Oh, if the main, that is only maintenance. We're not on the maintenance.
Because, my lord-
We're on the award of the contract.
Hmm.
So if it has been completed, if the works is completed, then what remains?
That's there, my lord. But whether it has been completed as of now, that's part. I have no idea. my lord.
We'll take it up. You inform the
Standing,
standing council.
standing council-
If it is completed, we'll.
Yes, madam. Therefore, I'm saying that let the matter be fixed on 30th, so that standing council,
Where is it? Today
I think
not-
he's out of station. I've been told that
No, not the standing council.
Jimmy Tara.
It's private.
Okay, then.
You inform Mr. Jitara.
Your Lordship, Your Lordship, at least one
See,
opportunity may
where
be
if
given.
we, the
Since he
report
is
of
out
the
of
matter,
petition.
nothing, no prejudicial cause to you. Just wait.
Oh. At least Your
Your
Lordship.
senior will be happy.
Okay. Your
That
Lordship.
it's in your favor.
Mhm.
You inform Mr. Thak.
Okay.
We'll take it up.
Then, my lord, on 2 o'clock, that's taken up.
Why? Why?
Because my lord, similar matter is also pending there. That's why
Where?
544, WC 544.
Why?
This court.
Similar matter?
Yes, ma'am.
We'll take it up this. And if similar matter is there, we'll get it fixed. You mentioned for that.
Okay, I'll do.
May I, Lordship?
Yes, yes.
Lordship, I beg to mention item number 20 and 21, Lordship.
20?
Your 20 and 21, Lordship.
Yes.
Your Lordship had once appeared in the same issue when
Uh, this matters before another, before any other appropriate bench without me. Huh? Yes.
obliged.
If I may please, Your Lordship, I would like to mention item number 13.
Item number
13.
30
13.
13.
This is a GST matter, Your Honor. As per the budget and announcement by the Finance Minister, there are some changes in the GST Act, which
Yes.
will,
So it has
We-
become in process.
yes, which
Matter
will,
has become in process.
infractures as in, yes, we need to take some instruction from the client. So if we are supposed to go further with the case or not, so it may be listed after 2 weeks, Your Honor.
Okay. On the prayer of MS
D. Riba.
Diriba, Learned Counsel for the petitioner, please this matter after 3
2
weeks.
weeks, 2 weeks.
2 weeks.
Yes.
So as to enable her to obtain instruction as to whether the as to whether there remains a live issue to be adjudicated upon.
Much obliged.
Mr. M. Kato, London for all the DSJ is present. What it has become infrastructure.
There is a certain modification in it from.
There are some changes in the GST Act.
Later.
I plead your lordship. Lordship, this is a contempt case, my lord.
Where is the order?
Uh,
Where is the order?
Order is at page 33, my lord.
33.
Yes, the operative
In
portion.
view
is-
of the above, this code is of the view the remove. The last one,
Yes, my.
it is however made clear that all the lawful owner, what is this processors?
My lord, my lord, this project was taken up, my lord.
What is this processors?
Possessors, the land owners, my lord. Private land owners.
Then owners are called processors.
Yes, my lord. Land owners oblique possessors.
No, it said you read it, processors.
Yeah. This is. Or maybe, my lord, the typographical error.
Typographical.
Yeah.
Okay.
It should have been possessors, my lord.
They have not compensated you.
Yeah,
The landowners. Are you a landowner?
yes.
But it is recorded that this
No, that may be, my lord, ascertained by way of, my lord, assessment and
how many petitioners?
16 petitioners.
Out of 16, 5 are not there.
Yeah.
5 petitioners are not the landowners.
That is not now established, my lord.
No, it says. It is also even after interim order, Kebang was held, in which it was reconfirmed that the 5 petitioners do not have any interest in the connection with land. It has been observed, recorded. You have not challenged this. Anyway, 16 out of 16, 5 are not the owners. Heard Mr. N. Pada, non-counsel for the petitioner. This is an application under section 12 of the Contempt of Court Act 1971. Article 215 of the Constitution of India and Rule 9 of the Guwahati High Court, Contempt of Court of 1970. Issue notice returnable by 4 weeks. Mr. And further, learned counsel for the learned counsel to take steps for service of notice upon respondent member. All the respondent oblique alleged contender. Number 2, 3. Why directly 5?
Yeah.
Page 8. Page 8.
Yeah.
Why jump to directly 5? Page 8.
Yes, ma'am. Respondent number 5, my lord. He is the deputy commissioner.
No, you have say 1, 2, 3, 5. Where is 4?
Sorry, my lord, did this typography,
I pointing it out
Hmm.
to remind you to be careful.
yes,
All right.
I'm sorry, my lord.
1, 2, 3, and 4. Huh? You correct it.
Yes, ma'am.
Register post with AD. Within 3 days. This after 4 days.
Obliged.
Item number 2.
My lord, may kindly pass over the matter for time being, my lord. The engaged counsel is on liaison code number 1.
Made with Lordship. So item number 3, 4, and 5, identical matters, only that the package of the tender is different. Also, the scope of this writ petition is otherwise very limited.
Yeah.
Why I have come
And we
today,
dismiss if it's very limited. then
limited, but it may be,
Your pleadings are also limited.
yes, Lordship, because it is limited.
Will issue notice, that's all.
No, because
Nothing else.
my prayer, Lordship, is what has happened is we have been disqualified in both the two packages, item number 3 and item number 4 for this petitioner. Now, what they have indicated in their minutes is reference to a particular clause. Now, if a Lordship,
Where it is.
yes, Lordship will kindly see first page 23.
23.
23 is the NIT.
No, I'm asking about that rejection.
Yes, Lordship. Then Lordship will come to page 120.
120.
120. Page 121. Serial number 2, MSHB Enterprise is the petitioner, and last we will see 2, the evaluation, non-responsive, HB Enterprise, non-responsive. Now they refer to 2 clauses. As per evaluation and scrutiny of the following clauses have been attracted. Clause 4.2.d, section 2 ITB, 4.4b, B2 of the appendix to the ITB. Now, if I take your Lordships to these sections, the Lordship will see that these are general clauses. It says that if documents regarding the construction equipments, there is some failure, it can lead to disqualification. And the other clause is related to personnels, the number of personnels. They don't refer, if a Lordship will come to page 35, just for a understanding of these clauses, page 35, clause 4.2.d, page 35. Page 35, section 2.
Yes.
Yes, Lordship will see clause number 4, qualification of the bidders. They have referred to clause 4, Roman B, B, small b, and then small d, 4, 2, D. That is at page 36. I'm just reading D, page 36. Evidence of ownership of major items of construction equipments named in clause such and such of an evidence of arrangement and possession of them, hire, lease, buying as defined. Now it says major items of construction equipments. Now, which one are they referring to? We have given all the requirements of all the materials and the equipments that will be required. Now they are saying that I have made a default in this. They have to indicate whether it is a dumper, whether it is a JCB machine, whether it's, they'll have to tell which particular equipment or instrument that they are saying that it is lacking, that I have not given the evidence. Now, if a Lordship will see the clause, it's generic. It doesn't refer to anything. So how am I supposed to respond to this? Because for a construction work of road, there will be n number of equipments and machineries. So they are now saying that evidence of ownership of major items.
4.4b.
Yes, that your Lordship will come at page 37, 37, 38. (37) 4.4b for 4.4b small b at page 38, Lordship will see the exact clause, Roman 2. Availability of construction work of technical personnel as stated in the appendix to the ITB. Now, if your Lordship will see the appendix to the ITB, which your Lordship will find at page 51. Page 51 is the appendix to the ITB, and the concern clause is at page 54.
Truck mount water tenders.
Clause 54, page 54, 4.4b, small b, Roman 2. Lordship will see the technical personnel. There is a list of persons.
These are the things,
Lordship.
these are things which you are supposed to submit.
Exactly. So here, which personnel, where they are finding the fault? If your lordship has seen page 54,
So in that case, you cannot say that you call this 4.2 the generic.
lordship, there are two clauses that has been referred to here.
No, see,
Yes,
you are
Lord.
saying that it's generic. Evidence of ownership of major items of
Items.
construction named in clause 4.4b. Small b, Roman 1 of
Yes.
ITB. Then when you go to that, it talks about the appendix. Appendix clearly provides.
Page 51, yes, yes,
Materials and
yes.
equipment. Then
So,
what is the
no, my
question?
case is,
Generic.
which equipment? If your lordship will come to page 51 kindly, page 51, the list is given. Major items, they say evidence of major items. Which item are they finding fault with? Lordship, please see the list at page 51 kindly.
Where is your list? Where is your documents to show that these items were, I mean, the equipments were submitted?
Lordship, this is a list of 23 items, 29 items,
Yes.
total more than 50 items.
Yes.
So they have to indicate which item, because I have submitted my bid. It's a voluminous bid document. I have submitted to
No,
them.
unless you show us that
No, it
these,
is-
these
it is-
items have been, the major items which you have
No,
submitted.
Lordship, we
you
can,
have said
we will
the-
have to look at it in the other way. There are total 50 items. No, just Lordship will bear with me. There are total 50 items.
They have rejected.
They have
whatever-
rejected saying that the evidence of ownership regarding major items I have not given. Which item they will
You
have to
show us
indicate.
which-
It is
show-
for them to point out.
You show us, you show.
Then I
us
have to bring, the Lordship will ask for the entire bid documents.
These documents, the equipments have been submitted by you
Yes.
as required, where it is.
I have to produce the entire bid
You
document
have
then.
to-
So we can just cut short the exercise by asking them which item they are finding fault with. Lordship will see. Truck
Sir,
mounted water tanker.
Burden is on you. Not
No,
to
no, no, Lordship. Burden will come to me once they point out
them.
where they
Pointed
have.
out, You have not, I mean,
I think, Lordship, the entire process becomes cumbersome.
you are supposed to submit these items.
Yes.
According to them, you have not submitted.
My statement in paragraph 9 and paragraph 12 is that I have submitted all the documents.
Okay, we'll consider.
Now, it is for them to
What
indicate.
happened?
Why can't they, why can't they tell us?
My lord,
You tell him.
We had also,
now technical bid open
but that is true, but they cannot accept it.
18/6. It was in the month of June. Now we
Yes.
are in the September.
Yes. In the meantime, in the
Why
meantime,
you-
In
see,
their pleading, he have not stated that
Sir,
justifies.
Sir, he may be correct also because you are rejecting his bid
Yes,
by giving these clauses. These clauses provides, say, 50 items.
yes.
Which items or which equipment he has not submitted? The ownership, proof of ownership, whatever.
Yes.
You have to clarify. Again, you have to read along with this 4.4, 4.22 appendix.
Yes.
That's why I just pointed out the provisions of requirements of submitting a thing is not generic, but your rejection appears to be generic.
yes, that
Now-
I stand corrected. That's what I wanted
Now
to make.
petitioner has to show
No, no, not me.
that ground which it is reject. That clause I have. He have not
Sir, what is-
whispered anything in the writ petition
Sir,
also.
what is the difficulty pointing out, giving them these, out of these, you are supposed to submit this, you have not submit that. He has filed a representation.
No,
They have,
They-
Have you filed the?
we had given an RT, we had
they have not filed representation,
we
but
had-
they issued legal notice.
we had issued a legal notice. They have replied to that. Again, in the reply, they cunningly avoid disclosing where they have found the fault. They simply say that everything is in the website. It is not in the website. Otherwise, we will not come to the court. Lordship, we'll just appreciate one thing. Lordship will just
That's
appreciate one
hard to believe. Whether in the website, no, sir, you will definitely come to them.
No, no, but then I would not have.
The moment your bid is rejected, you'll definitely come.
No, that then I would have made my petition in a better way. I would have addressed that particular point. I would not have come with the
So
limited scope.
therefore, your petition is itself is also equally, it's a generic.
No, it cannot be generic because my hands are tied.
Yes, yes.
My hands are tied. I cannot say anything. Lordship will
No
appreciate one
agree
thing.
person will
Anyway,
wait for 2
I'll
months.
issue notice. That's all.
Lordship, I'm just
Only-
praying. Lordship, I'm just praying, Lordship, because I will have to challenge my disqualification finally if the points are raised. If they can bring the instructions. Lordship, will you appreciate one thing? While rejecting me under that clause, they must have checked all the items to see the ownership. and then they must have found fault somewhere. Just indicate which equipment you have found fault. They have,
Mr. S. Sharma, learned
A. Sharma.
counsel, A. Sharma, learned counsel.
let the instructions come within 1 week,
Mr.
Lordship.
A. Sharma, learned counsel for the petitioner. Next para, by filing this application, filing this petition, the petitioner has put to challenge the technical evaluation report part 1 dated 10/06/2024, by which the technical bid of the petition has been declared as non-responsive. Non-responsive. What is that rejection? 121.
Page 121.
On the ground of no, on the deficiency of for non compliance of the clauses of ITB non compliance of
Specific regions, Lordship.
clauses 4.2.d small d of section 2 within bracket ITB 121 and clause B, clause 4.4 capital B bracket small b bracket close bracket Roman 1 Roman 2 small Roman 1 Roman 2 bracket close of appendix to ITB. Mr. Next paragraph. As A. Sharma, learned counsel for the petitioner submits that while rejecting the technical bid of the petitioner, the respondent authorities have not specified particularly which major equipments the petitioner has not submitted. The rejection is generic in nature. Therefore, he submits that the rejection of the bid of the technical bid of the petitioner by impute technical evaluation report part 1 dated 10/06/2024 is arbitrary. Issue notice returnable by 4 weeks.
So that way, my case will frustrate, Lordship,
3
because
weeks.
they will give the work order to someone. I have a prayer of interim prayer also.
Already started at this moment.
Already started. Is yet
My
it's about
instruction
to
is
complete.
that way ultimately my case will be frustrated. Lordship will appreciate that. Therefore, I was saying, let the instructions come.
Then
Let them give us the details on which ground they have disqualified. If it is fine, then we have no case.
this filing this insurance, the petitioner has put to challenge what that challenge the technical. Just read the first 2 lines. Pursuant to the NIT
It's 23.
dated 26
26 to 2020.
26/02/2024 for construction of what?
Road, Lordship, from
For
Taskin to-
construction road from Taksin to Ojugu
Ojugu in Daporiju.
under
Under
in
RWD
Daporiju,
division,
under
Daporiju.
village, a vibrant village program.
Yes, Lordship.
You had that. Since Mr. G. Tarak, London Standing Council for RWD, enters appearance and accepted notice on behalf of all the respondents. No formal notice need be served except for this London Council. During the course of the day,
Yes, Lordship.
no private respondent.
There is a private respondent because
Petitioners take steps for service of notice. Upon respondent number
respondent number 5.
5. Within 2 days. Within 2 days. The award of the next paragraph. Award of the contract in question shall be subject to the outcome of the rate petition.
So we'll kindly fix a date.
After 3 weeks.
And on that date, let them produce the records of the disqualification.
Yes.
The minutes that they are holding will definitely have a disclosure as to on what grounds they are finding me default or short lot.
Yes. You produce,
Only those 2 lines also.
you have filed an affidavit, what's there? We'll dispose them on next day.
Yes, we'll try to file affidavit.
Because they have
Uh,
checked all the 50 items, they have must found that this
Next
here
year.
is all shortfall.
Considering considering that the issue pertains to NIT. Come on, the respondents are at liberty to, are directed to file their affidavit and produce their record on the next date fixed.
Fix a date.
Next, list on
Any date will losses convenience
give-
after 3 weeks.
after 3 weeks,
After 4 weeks,
3 weeks.
the 4 is.
Then they will say, oh, okay,
It's-
50%
it's a-
complete. There's nothing to be done now.
As a age of technology, electronic.
These are all available in their
Yes.
online portals and whatever.
After 3 weeks, you just agree.
Yes, Lordship. So the other 2 items,
Same ground.
same
Same.
grounds are also same, but the
this-
packages are different.
Ah,
Item number 4, at
Yes.
page, again, the report is at page 120, Lordship.
120,
120,
item 4.
item number 4.
Ah.
Page
The-
121,
for
are the
construction of
construction of road from
for-
Taskin to Tying.
tying, huh? Then item, same ground, rejection is on the same ground.
On the same ground for this also.
120, huh?
One
Then item 5,
And item number 5, petitioner is different and the report is at page 115.
same ground, construction road,
Construction of road from Kyojuring to Chokar.
Dapuruja.
Everything is Dapuruju.
Sequence.
Dapuruju. And the clauses of rejection is page 116. Again, generic clauses,
And-
equipments. Which equipment they don't say.
Okay.
Obliged also.
Item number 6.
Your Lordship, kindly pass over the matters.
Why?
Leading counsel in court number 1, the bail hearing is going.
These are not yet filed. What is your stand?
Lordship, his claim is that. he
But
has-
his,
date of
as
birth
per,
is-
as per his the school certificate and date of birth certificate,
Lordship, school certificate, we have verified the school certificate. It says that in the fire accident, the school was damaged and the documents are not traceable. Has been damaged, Lordship, in the fire incident, not fire, Lordship. We
so
have a
benefit of
completed
doubt,
As per appointment, his date of birth is 1961.
it's okay, appointment can be recorded anything, but then you see, he has produced the school certificate also, birth certificate,
Lordship, birth,
page 27.
Lordship, birth certificate.
You try to find out who said it was
Lordship,
born,
born in 1961 or 70 and let's. Lordship, getting the birth certificate in 2020, Lordship, Lordship, how can it can be, Lordship?
Hmm?
Taken as, Lordship, authentic.
no, it's before his appointment, 18/2/2005.
Lordship,
Certificate,
this-
page 27. This birth certificate. And then the school certificate is transfer living. 4/3/26, before his
Lordship,
appointment. His appointment was in 2009. Right?
that is as the, this, Lordship, as WC, Lordship, SWC. But then he was appointed in 1989, Lordship,
89.
yes,
Okay.
engaged in 1989.
So, did you try to find out the exact age? Apart from relying on the record of the service book.
Lordship, we have in page 26, our reply, Lordship. We have written to the school headmaster, Lordship.
Affidavit. Affidavit, page 26.
Yes.
Yes.
Lordship, the reply of the school headmaster.
Pursuant of the
Lordship.
letter above, I have verified our admission register and other.
Lordship,
records of
here,
the school of the
Lordship, we will see, school admission record not found.
Not
due to
found
some
due to Assam
agitation.
agitation year nineteen
Yes, Lordship.
seventy. School attendance register of the student.
Lordship,
And
from all of this, it can be made out that this are not authentic. The
School certificate issued counterpole form. Where is this? School certificate issued counterpole form.
Lordship, when all the documents had been, Lordship, damaged at
So
claim.
this school certificate,
Counterfoil, where from
No.
counterfoil, Lordship?
school certificate issued counterpole form, it is not a problem because counterpole will be there. Because he has obtained in 2006, right? He has obtained the certificate in 2006.
Yes,
So counterpole will be there.
2006.
School admission record not found due to Assam agitation year 1979, 1980.
School attendance register also damaged. Lordship, how can this be? When all the documents are damaged, Lordship. And then Lordship, what we are stating is that if his claim is true, 1970, then 89, he's only 15 years. Lordship. That cannot be when he was engaged. In our, this one, Lordship, statement.
He was
Yes, para five.
appointed as what?
He was not. They were levels, Lordship, casual levels, casual role, Lordship. Page 4, Lordship. In 2009, Lordship, he was appointed as WC Assistant Carpenter. Lordship. Before that, he was casual level. Lordship. He was engaged as casual labor in 1986, Lordship. And in that case, if he, Lordship, he will be 15 years only. If his claim is also true, Lordship. Even if his claim is true. Page 6, Lordship, second para, we have stated that he was engaged as casual labor in 1986, Lordship, second para, page 6.
How we easily discard this certificate?
Lordship,
How do we easily discard the certificates?
Lordship, actually, this also was brought to notice only very lately, when we already given, has served in the retirement notice.
Yes, when you were appointed on 2009, it was clearly mentioned about your date of birth,
That's 1961.
1961. How fit you are?
Your Honor,
Very old. At that point of time also is as per verbal information.
Otherwise, he's just 50 years old.
Yes. If it was only 2-3 years here and there, it could be different thing, but then it's a gap of 9 years, 9 or 10 years.
petitioner is around. He is around the court premises.
No.
So what is to be done? Who is appearing here?
DK Deori, leading
After
counsel.
some time.
Wait, please, Your Lordship.
Item number 2. Yes.
Item 2. Here instruction was called for. No, the challenge made in the repetition is the technical evaluation.
Yes.
Whether the response number 5
And the
and
instruction.
My lord, in this case,
Hmm.
petitioner as well as the respondents are qualified in the technical bids.
Yes.
Now, in financial bid, the petitioner has L5.
Ah.
L4, 3 and 4 is not before this court. They have only read L1 and L2.
Hmm.
So once he participate in that financial bid, so he cannot turn around and say that technical part of the petitioner was this and that.
There is technical. What is the merit? What is on merit? What is your ground of
the
challenge?
technical evaluation, well, there are documents which have been submitted by response number 5 and 6, which are absolutely apparently on the face of it.
It's
fourth
okay.
document. Fourth document.
Forget about that.
Madam.
You have, your technical bid was found to be responsive.
Like, my bid was responsive.
Then
The response number 5 and 6, who has submitted certain documents, which apparently on the face of it, my lord, does not-
who is L1? 5 and 6?
or 5. response
Five
number
is-
five.
And the petitioner herein, he was there in the financial bid representing some other part.
Hmm.
He was also during the opening of the financial bid. So after
But
that,
then yours financial bid of L5.
My lord, when the technical evaluation was done, immediately thereafter, we have filed a complaint before the authority that this technical evaluation has.
So if 5 and 6 is out, you will be in,
I may be,
but you will not.
I may be.
Because you are in L5.
Yes.
Let us assume that they are not qualified. Let us throw them out.
But that
Five
will
and
not,
six.
my lord, they will not.
Just wait. I mean, first you will have to have a claim.
My lord, that will not cure the illegalities that is committed by the respondent. of
It's
the-
all right. It's all right.
If your lordship will just
So
see
it's all right.
one document.
First you establish.
My lord.
Suppose let us throw them out.
My lord,
Where do we stand? L5.
L5.
You will not get.
I may not get it, my lord,
Then-
but that will not,
First, unless you show that you will be eligible, will not.
but with lordship exercising
Maybe
the
they have
20
an envelope with
jurisdiction will not
L4 and
perpetrate the
L3.
Is
illegality.
there any serious allegation?
Yes, absolutely. If your lordship will see in it, my lord, page 123 is the affidavit which has been filed by them.
123?
Page 123 is the affidavit that is filed by the response number 5, disclosing for the purpose of showing his qualification as a bidder.
Yeah.
Now, if your lordship finds page 125, serial number 1, just down below water tanker, your lordship will find this vehicle number in the first page itself.
No, it's not.
No, my lordship will kindly.
It's not a court of this job of this court.
No, my
To
lord,
find out
why
these
I'm
are-
saying so?
These are correct or not?
No. This is an affidavit on oath that this is the vehicle which he
How do
owns.
we verify this is
There is an RTI report from the,
false or has been given?
no, my lord, from the RTI report.
Have you filed?
Yes,
have
page
you-
130, my lord, the
Huh?
RTI report. Your lordship will find these two vehicles shown as Ashok Leyland vehicles. Now, my lord will find page 130. It's a scooty, my lord, registered in somebody else. He claims to be a owner of this
This is
vehicle,
furnished by whom?
my lord, by the
Third party.
motor vehicle inspector,
Third party.
my lord.
Third party. He's a third party, furnished by third party.
No. It is a MBI.
But then in this case, he's a third party.
These vehicles, matlab, these vehicles has been shown as Ashok Leyland heavy vehicles. Now, when the RTI report comes, it says it is a scooty in somebody else's name. Well, it's an apparent fraud, my lord. And apart from that,
Have
now,
you filed a criminal case?
my lord,
Have you
Yes,
filed?
we have lodged a FIR also against them.
You wait for that.
But that's a different thing, Milord.
Yeah, that is
but-
different thing. That things will be taken care of by the criminal proceedings or
No,
in the
that
criminal.
for the fraud commission of offense is a different thing. But
Unless it is proved. Unless it is proved.
yes,
We cannot.
but the authorities,
Take
always the
cognizance of
tendering
it.
authorities always have a authority to verify these documents. Because as per 4.7 of the ITP,
Sorry,
he is
sir.
supposed to, my lord, disclose, and this is one of the ground of disqualification. If something is falsely and misrepresented before in the affidavit. Now, this second, it's not the one thing only. The other,
Moreover, it's a contract.
and for the same documents,
We're not sitting,
my lord,
we're not exercising the PL jurisdiction.
No, I
I
have-
agree. If it is correct, it's very serious.
yes, very serious.
But
And I am a
but-
bidder, that's so.
so far as
possibly, my
the
lord.
fraud
Yes,
is concerned, it is yet to be established.
but from the lordship, my lord.
We'll
for the-
dismiss with a liberty,
my lord, if
with
your lordship-
with a liberty to approach the appropriate forum, including this court, as and when the matter is finally, the decided
my lord,
that
there is,
whether there was a fraud or not, with all damages,
my
compensation,
lord,
and
if I may point
everything.
out one thing.
Yes,
My lord, this is not the only thing, my lord, which we are pointing out. There are other documents where he once says that I am the owner of this vehicle, and he's in support, he gives a lease document.
that's why I'm saying, sir.
And these are the
Now, first of all, fraud has to be established first.
this,
To
uh,
take on record that he has committed the respondent has committed a fraud. Number two, even if they are disqualified from participating, including the technical bit, it doesn't.
But the first point, my lord, in respect of what
Within
your
the
lordship is
bill-
pointing out, from the record, it has to be established that there is a fraud. The documents in support of the affidavit, which is submitted before with the tender documents, are itself enough to establish the fraud, my lord. And therefore, my lord, on 980, your lordship will find page 147. Immediately after the technical evaluation was done, we submitted a complaint before the authorities, pointing out all these documents which were submitted by him as a bid document. It is nothing, my lord. I am not bringing any new document to establish a fraud. From their document itself, he says in his affidavit that this is the vehicle which I own, but in support, he give a lease agreement. In one vehicle, he says that I am the owner of this vehicle, and in support, he gives a quotation, my lord, which is during the purchase, he had a quotation from the showroom. So these are the documents, my lord, which was apparently from the affidavit is required under section 4 of the clause 4 of the ITP. And 4.7 says if he misrepresent or falsely state anything in the affidavit, that's a ground for disqualification. And therefore, to invoke that, my lord, we filed an application representation. The authorities ignored that representation, went ahead for financial evaluation.
Yes.
But that's what my case is, that this is what the illegality that has been committed.
But eventually, what would be the result for you? Eventually, what would be the result?
Well, in my respectful submission, once there is a fraud, it vitiates everything.
Do you want to have a fresh tender?
No, that is the authority who will decide. Your lordship will find that
See,
before the technical evaluation.
See, that is the problem. It's a contract. Now, it involves a public interest. Now, if we hold that the respondent 5 and 6 ought not to have been accepted bit of this respondent 5, then they goes out. Next, who will be there?
It may be the respondent 3 or the L3, or I may be, because my documents and his documents has not been accessed. Because the moment lordship will kindly
Petitioner
appreciate-
represent L3 in the bid process.
Yes.
So,
Who is L3?
L3 is KK Enterprise.
Who is this?
It's not in the party. Now, he again approached this court for other firm. Roya. Yeah,
The petitioner number 2.
petitioner, yes.
No, what, this is one
Petition-
petitioner just.
One petitioner, if represent Eka Enterprises.
Is the authorized representative.
Roy.
Page 26 on 9/8, he was authorized.
And he represented the,
KK Enterprises, L3.
okay,
That instruction.
There is hand and gloves.
I'll have to take it.
see, that's the reason I have observed. I mean, orally, it's not recorded.
Well.
The moment your tender is rejected, these people approach. This has to be,
Even for the same tender, in a different, under the same district
exemplary
of a
cost
different
has to be
packet,
put in.
the respond number 5 for the
How
same.
you are interested? You represented the one Messrs KK Enterprise, and you are filing a petition on behalf of the others.
Eka Enterprises.
Are you brothers?
Let
These KK Enterprise and Eka
Let my
Enterprises
friend-
are brothers?
my friend hand over a copy
Or
to
the,
me
or the,
also.
or the
so that I
family,
can,
family
he is-
members?
Malak,
This is more serious
let my friend hand over a copy to me also,
because,
so that I can take an instruction, Malak, because he's
yes,
producing it by bringing it as a surprise.
The last time also I had. referred this.
It was never been produced before. And not even.
see, your allegation is
Yeah,
also
yeah,
very
yeah,
serious.
Malak,
Equally, this sort of practice,
that be
and
so,
the
Malak,
conduct
of
of the
course,
petitioner
that-
is also
Malak,
equally
Malak,
serious.
I have to be very fair to you. If that be so, Malak,
Because this
something is-
court never and would decide a matter on the personal knowledge.
exactly not, absolutely not.
You
In
just
fact,
decide on the
absolutely.
materials placed
Lordship
on the,
exercising
before the court.
226 will not perpetrate any kind of illegalities, whether from the petitioner side or for the respondent.
So that's why I'm asking.
Yes, Malak,
This Messrs KK Enterprise and the petitioners are brothers.
Malak, I'll have to take.
Are they family members?
I'll have to take instruction. This is something,
I'm busy, so you represent my brother.
Malak, I can't answer this until your lordship give me a opportunity to take
Okay.
the instruction from my client.
You just produce, you give the
I'll
copy.
get the Xerox.
We'll see, we'll consider, but then you also file the affidavit. We'll issue notice, right?
Malak,
You just, we'll
We'll-
take instruction,
yes, yes,
we'll fix next week.
Friday, maybe, Malak. or-
Otherwise,
Right.
my lord, this is pit case for dismissal since he took part in the.
Malak, if that be so,
Financial
if
bills.
that is what my submission to my learned friend
There
is.
you bring on record, where you file the affidavit, whatever you want to say.
So
that
the
we can-
petitioner cannot play the role of the technical evaluation committee.
It's all right, but then you
But the
place
technical
whatever,
evaluation
you
committee.
place
is
on
sitting there.
record.
Malak, even the technical evaluation committee
Mr.
also cannot perpetrate illegally.
Be cautious, learned counsel for the petitioner. Next para. This writ petition has been listed for obtaining instruction, listed for placing the instruction and to produce the records by the the endeavor shall be made to dispose of the matter on dispose of the matter. Next, however, today, no, not however, today, Mr. G. Thara, non-standing council, has placed documents which indicates that the person who is who is representing the petitioner, representing the petitioner in the matter is not a representative of the petitioner, but a representative of one MSKK Enterprise. This too. Next minute. Mr. Learned Council, the Learned Standing Council has also produced the certain documents to which reflects that an agreement has already been entered into with MS Melo Enterprises. That respondent number 5.
Respond number 5.
Respondent number 5. And the letter to proceed with the work has already been issued on 06/09/2024. Next period. Considering the allegations and counter allegations made by the Learned Council for the parties in this proceedings, I deem it appropriate to issue notice to the parties. List of. Or you'll just obtain instruction on this.
On this, I can obtain instruction on Friday. But if your lordship issues notice, then possibly they will have to file their affidavit.
In that case, I deem it appropriate to allow, not notice, huh? I deem it appropriate to allow the Learned Council for the petition to obtain instruction. Mr. The Learned Council for the petitioner is also directed to file affidavit. The copy of the instruction regarding the, what is this? Technical evaluation.
The evaluation represented during the
What is
financial.
What is this documents there?
During the financial evaluation, they represent the part.
What is called? What this document is called?
Attendance sheet.
Attendance sheet. A copy of the attendance sheet shall also be furnished to a copy of the attendance sheet produced by the Learned Standing Council be furnished to the Mr. B. Kaushik, Learned Council for the petition. You file an affidavit
Yes, I'll get it.
Taking up on Friday.
Friday.
Right.
List this matter on.
Grateful.
Friday is what?
Friday.
Which date?
13th.
Hmm? 13.
On that day, I'll apprise your lordship on this.
Yes, yes.
Grateful. Man.
Item number 7, 8, and 9.
Yeah,
It
please,
has
my
been
lord.
listed.
My lord, we will file our rejoinder. This matter, the
You have not. You have-
rejoinder, yes, my lord.
But office
We need
note
some-
says different. Office note says otherwise.
My lord, as I have
Just the
communicated with
reverse.
Learned,
No affidavit in reply.
no, we will file,
That's what I'm saying.
yes. We need some time to file our rejoinder.
What is the matter?
This is regarding the 13 pay as compensatory pay for the, under police department.
Similar matter has not been.
Earlier,
Yes, this is in pertaining to the transport department. It went to on our division bench and that was dismissed.
This way. Don't take risks before this court. Mr. H.K. Jamo, Learned Council for the petitioner, respond and granted
3 weeks,
6 weeks times to 3 weeks,
minus
3 weeks time to file affidavit in reply.
highly obliged.
Item number 10, 12.
Yes. Jimmy,
I know this is already in practice. I am told that they have submit representation for release of the EMD. And moreover, work is in,
Part is there, 5 years.
work is in the verge of completion.
Mr. K. Tari, Learned Council for the petitioner. petitioner, separate order, same order but separate order. The learned counsel with the parties have submitted that the matter has become infructuous.
No, my lord, my part may be recorded, and paragraph 7 is there, my lord, that's part may be recorded, and maintenance part. That's only my submission recorded and only his submission, that it will be disposal.
No, if you are agreeing for disposal as a infructuous, then matter is there.
I'm on the merit, my lord.
This is construction approach road with bricks.
It's completed.
In the bar completion.
As per NIT also, maintenance part, 5 years for maintenance part is there.
Now is also no more interest. He have applied for the release of EMD.
Submitted that matter has become infructuous. As the working question has already been completed.
Only my lord. Observation.
Accordingly.
My submission, my lord.
Accordingly, the writ petition states dispose of as infructuous. Otherwise, you have to oppose that it is not infructuous.
My lord, yes, I'm the
You
merit,
say-
sir. I'm saying that.
No, you said
maintenance
that
part-
it may be disposed of as infructuous, but then you want to get it recorded. It's not possible. Either
was-
we'll go by the
Maintenance-
disposal on merit or it has to
Construction,
come in.
obviously, I agree, construction part is infructuous, become infructuous. And maintenance part of your, it's also, well, yeah, but-
What is that? You
Maintenance part.
try so much.
Obviously.
Big businessman, do
No
something
problem.
more good for the state. Don't fight for this petty, small thing.
Same order, my lord.
Huh,
Same one.
same order. Yes. There's no office note. It says, office note is there.
My lord, I have served the notice.
I know.
Joseph, if extra copy can be served to me, I'm for R1 also.
Why?
Extra copy here.
Who's the in charge? Who's the in charge? Who's the in charge? Registry. Who's the registrar? So who's that? Who's in charge of the office? Who is that? Tell me. I don't know how this has been explained. You furnish the extra copy.
Okay.
Had Mr. Sorensen learned counsel for the petition. Next matter, the Mr. Esther learned senior government advocate. is
Joseph,
granted.
here I'm extending counsel for APSS.
Okay.
R1.
Learned standing council. APSSB.
Yes.
Press for and is granted. 3 weeks time to file affidavit. List of learned counsel for the petitioner to furnish extra copies during the course of the day. If furnish extra copy, otherwise they'll not
Yes.
file.
Applies all.
Matter has become infructuous.
No.
Huh?
This matter may done for today. I am on behalf of NPADA for extending council tourism department.
Office note dated 07/09/2024 reflects that no fresh steps has been taken for service of notice upon respondent number 13 and 14. Mr. Petitioners to take steps for service of notice upon respondent number 13 and 14. This after 4 weeks. Who is for the petitioner? Anybody appears for the petitioner? It's 2015 matter. Just wait, huh?
My lordship. Item number, lordship, we need to
15. Who is appearing for the petitioner?
Your Honor, item number 19, Your Honor.
You find out Mr. Soki or Deeta Mukh after some.
lordship, item number 16, we need to file a rejoinder. So kindly give 3 weeks time. to
On
file
the prayer of Mr.
P. Rolling on behalf of NPAR.
Learned Counsel appearing on behalf of Mr. N. Father, Learned Counsel for the petitioner. List this matter after 4 weeks. So as to enable the petitioner to file affidavit in reply.
Yes.
Mr. Wairam, London State Council is present.
Hello,
Your Lordship.
may also be recorded.
Then in that case, Mr. D. Kamdu, Land Standing Council, Land Management, and Mr. D. Shoki, D. Wairam, Land State Council are present.
And your lordship, I am on behalf of BP Chai Standing Council, NIPCO, 7189.
Then record all 3 of them
Okay.
are present.
Obliged.
That's all. Affidavit in reply, not yet filed.
Yes, lordship, in this matter, we are supposed to file affidavit in reply, lordship.
On the prayer of Mr. Swens. No, on the prayer of Mr. Swenso.
Yeah,
Counsel for the petitioner.
Yes, lordship.
List this matter after 3 weeks for filing affidavit in reply. MS so-and-so are present. Huh?
Obliged, lordship.
K. Wangmo for London State Council and MS For respondent number
4.
4 are present.
Item number 18.
My plate, my lord.
Yes.
My lord, here all the respondents are yet to file their affidavit.
Yes, why? What is the matter?
Land
Land
dispute.
dispute.
Yes, my. So
If
last chance.
No,
we will
if it
give-
is land dispute, go to the civil court.
My lord, actually there was a complaint lodged by me
Yes.
before the additional deputy commissioner. And additional deputy commissioner has interest my application to the circle officer. Then circle officer has issued order to the village authority to conduct a local man.
Yes.
So accordingly, local this mill was conducted, but that was not settled. That was not settled. But without any and with any settlement, they have issued one declaration letter in favor of the respondent number 10.
Yes.
So I have challenged that declaration letter.
By whom? What is the declaration? Declaration by whom?
Declaration by the Gambara
Hmm?
village authority, my lord. That is page number 32.
32.
My lord, there is a
No,
alternative remedy, my lord.
To whom it may concern? Where is the declare? Is it?
no, my lord, not that is. To whom it may concern is one of this supervisor. Has submitted this to whom it may concern.
Which
in favor
order
of
you are
me,
aggrieved?
my lord.
Which order you are aggrieved? You said some
My lord, that is
declaration.
page number 28.
28.
Huh.
28.
This is a private association.
My lord, actually, there was no any settlement. Matter was fixed, refixed, but
All Tali Area Gabura Welfare Association. It's a private.
Yes, my lord. This is
On this day, so we understand that we hereby declare that the land dispute case between so and so discussed thoroughly in the presence of the what is observed that the lands will take the way to the so and so. You file a suit.
my lord,
You file a suit.
if not, my lord, he can also file appeal before the district court also.
Huh?
District court also, in
Yes.
district court also, he can file appeal, my
Not
lord.
before this court.
Not before this.
my lord, here the
226.
You are agreed by this.
Does not
agree
write.
by this
Wait till it
letter
file.
of,
Wait till it
letter of-
file, or I'll dismiss on merit.
because there was no any such settlement, my lord.
Whatever.
Despite of this not settlement,
Either you, if it is, if you consider this the decision of the Ghabura village authority, you file an appeal. Appeal lies.
yes, my lord.
If not, you file a title, civil suit.
Earlier title was filed against this order, but that was done by virtue of this writ petition. Petitioner, here the petitioner has filed a writ this title suit. And that was withdrawn by virtue of this writ petition.
Why?
The writ petition was filed before this court and is submitted, so that cannot be run simultaneously.
So we'll permit you to approach. That's all.
My lord, with a liberty.
Yes.
So, my lord, my
Should I
submission,
dismiss on with merit or withdrawal?
no, my lord. My submission before this honor court, let them file affidavit.
No, it is not required. It's not required.
So, my lord, on merit, matter may be disposed of
Yes.
with the liberty to file a title.
No, if that will, I may not give also. If I had to decide on merit. You withdraw and file, will mention that in view of the pendency of this writ petition, you have withdrawn the title. Will
Yes.
give you a liberty.
Oh, my lord, I may be allowed to withdraw
Yes. Otherwise, on merit,
with a liberty. my
there's
lord.
no issue, but then in the process, we may make some observation also, right?
Yes, my lord.
Next para. Sorry, Mr. I heard Mr.
Enter.
Entaje, learned counsel for the petitioners.
Yes, my lord.
Present. And also heard Mr. Who is one?
1 and 2, my lord.
Mr. D. Kamduk, learned standing counsel for learned land management for respondent 1 and 2. And MS.
For three.
R. Basar, learned state counsel for respondent number 3. Next. Para. Essentially, the challenge by the petitioner is to the declaration letter issued by All Tali Area Gaobura Welfare Association dated 29/11/2022. You are Yura Tachik,
Yes,
whereby the head GB and GBs declared that a land dispute case between Sri Yura Tachik and Sri Gichik Tadak
yes,
have been whereby after not declare whereby after deliberation of the land dispute case between the petitioner and one Sri Gichik Tadak have declared that the petitioner has no right to claim the land within bracket Gangtung bracket close by granting the ownership to the said Sri Gichik Tadak the possession of the land and allowed him to execute all the pending work. On the land within bracket Gangtung. Next paragraph. Having considered that the any question agreed by the decision of the village authority has the remedy to approach the civil court by an appeal. Come on. And on the prayer of learned counsel for the petitioner, Mr. On the prayer of learned counsel for the petitioner, Mr. Entaje, who fairly has submitted that he may be allowed to withdraw the writ petition with a liberty to, well, with the liberty to approach the appropriate civil court. Come on. I deem it appropriate to allow the same. Accordingly, the writ petition stands disposed of on withdrawal with a liberty to approach the competent civil court. Competent jurisdictional civil court in accordance with law, in accordance with the provisions of the law.
all right,
Writ petition is still disposed of.
all right.
Item number 22.
Yes,
My lord, I'm for a petitioner.
yes.
All the pleadings has been completed. This matter may be fixed for admission hearing on 16th of this month.
Fixed for admission hearing.
Yes, Your Honor. On 16th of this month.
Pleadings completed.
Yes, Your Honor.
On Mr. Swenson, petitioner. And Mr. G. Kato, for,
I'm for the respondent number one.
learned DSGI correspondent, and Mr. T. Tapak, correspondent number, are complete. Pleadings are completed. List for admission hearing.
Obliged.
Item number 23.
So what is to be done?
Standing counsel Afik is there, Lordship, and
For the petition on call, MS. Which you are for?
I'm for Lordship,
You are for nobody.
no, Lordship, we have filed our affidavit also, Lordship. I'm for two. I'm wondering if.
Who is for one? Commission. And MSG at Learned Senior, Additional Senior Committee report. Respondent number 2 and 3.
Yes, Lordship.
Readings completed. List for admission after 4 weeks.
Obliged.
What is this IA?
My lord, for one is for condonation of delay for restoration of my writ petition, WPC number 505 of 2023, Your Lordship. My respectful submission is that on 17/8/2024, this honorable court dismissed my writ petition on Your Lordship non-appearance for the petitioner's side, Your Lordship, on yours. And most important,
Where
if
is
Your
that?
Lordship go through my IA application at page number, Your Lordship, 10 and 11, Your Lordship.
What is that order?
My lord, at page number 10. Operative part in page number 11, Your Lordship.
In this IA?
Yes, Lordship.
No, there's
One for delay condonation, Your Lordship, and one for restoration petition.
no, this IA is 159.
Yes, Lordship.
Where is that order of dismissal?
Dismissal is at page number 11, Your Lordship.
Delay of 18 days for restoration of being.
My lord, that is for the delay condonation petition, and that next one, next IA application where the order is.
Any objection? No. What is this dismissal?
My lord,
Yes, Your
on that particular day, we could not
Where
appear.
is the dismissal?
My
It's
lord,
in the miscase.
in miscase number, on the next miscase, Your Lordship, on that, this is for delay condonation, Your Lordship.
So I have not annexed that order. How do you know?
I'm sorry, Your Lordship, kindly pardon me for that, Your Lordship. At page number 11, Your Lordship. Yes.
This is a matter of
Matter pertains to irregularities, Your Lordship, in contractual work, actually, Your Lordship.
contractual work.
Yes, Lordship.
They are respondents. You will have to issue notice.
Yes, Your Lordship.
Formally.
Yes, Lordship, please.
Notice may be issued, Your Lordship.
But it's 18 days is no problem, but there's a private respondent
Yes, Lordship.
and it's a contract matter,
Yes, 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 yes. Contract matter, Your Lordship,
tender matter.
there is a,
It's a tender matter.
no, Your Lordship, this is not a tender matter.
What is
There
that?
was a contractual work under the Jal Jeevan Mission in Gasing village. The said respondent number 5 has done some irregularities and without completing the said contractual work.
So you'll issue notice because private respondent, they may say.
Yes, yes.
But Mr.
SD Roy, Your Lordship.
Learned counsel for the applicant in IA, huh? IA 159. This is an application praying for application under section 5 of the Limitation Act 1960, praying for condemnation of delay of 18 days in filing the restoration petition, filing the connected restoration petition. In filing the petition for restoration in connected MCW bracket WP, huh? Bracket close 02 of 2024. In connection with the for not in kind for dismissal for restoration of the WPC 505 of 2023, which was dismissed for non-prosecution on 18/07/2024. Mr. Y. Ram, London State Council enters appearance on behalf of the state respondent
124.
124. Therefore, no formal notice need be served. However, extra copies be so ensured. Next minute, the petitioners, the applicant to take stage for service of notice for respondent number 5.
Yes, Lordship.
Respondent number opposite party so and so. Number 5. This after 3 weeks.
One more prayer also, Your Lordship. Kindly reflect my name in the cause list, Your Lordship. However, there.
Why? It's not been
My name was
reflected.
not there in the cause list.
Why? Have you filed a power?
Yes.
The registry to reflect the name of Mr.
SD Roy, Your Lordship.
SD
Roy.
SD Roy, learned counsel for the as learned counsel for petitioner, applicant of petitioner in the cause list.
Item number 26.
My lord, this matter pertains to my lord rejection of my application for appointment,
Service report
my lord.
and Mr. D. Learned counsel for the petition. And Mr.
Correspondent number 1 of them.
M. Kato learned DSJ. Correspondent number 1. And who else are appearing?
My lord,
Chairman, Manager, Bharat Petroleum. Okay. Next minute. Office note dated 07/09/2024 reflects that service report in respect of respondent 2, 3, and 4 are still awaited. List after 3 weeks.
Lord, I have filed one additional affidavit, my lord, for bringing on record some documents, my lord. And that,
Additional, it's okay.
yes, my lord. That may be considered, my lord.
Today,
Yes, my lord, I have already filed, my lord.
it's okay. What is to be considered today?
These document, my lord, which I have annexed in my additional affidavit, my lord. That may be.
Heard Mr. D. Kamduk, no, Mr. D. Kamduk, learned counsel for the petitioner, submit this. He has filed an additional affidavit
Yes, ma'am.
to bring on record certain documents.
Yes, ma'am.
Please do. Same are taken on record.
Yes, ma'am.
Please. The Mr. D. Kamduk to furnish copy of the additional affidavit to the respondents.
My lord. Obliged.
Document number 6.
Yes.
It's a repetition which
If we consider that your date of birth,
certificate.
1970,
Yes,
you were 15 years. At the
15
time when you joined the
service,
service,
1986.
you cannot be.
That cannot.
It's not permissible. And
But-
the entire your consequential appointment promotion will be nullity. Then you have to
In those days,
you have
literally,
to refund all the benefits, salaries, and other things. So better enjoy your life. Your evening,
that is true because
you
they are
enjoy your evening.
5 years, 15 years, some months old only at that time.
Yes.
I was as per record, if I strictly believe on that particular thing. But those days, without considering the age, they used to,
That cannot be. We cannot allow. If it
but
is-
that
means
cannot be
the
presumed.
appointment was illegal in that
Yes.
case.
That cannot,
Engagement was illegal.
that
And
cannot-
it's not violates the service rules.
yes, equations is
And
a
they violates the, what do you call?
requirement of the service rules
Not
for
only that,
appointment. Even the child law,
child labor
Yes.
act. and
that,
other
that is
things.
that covered us.
So we'll
Child labor
break
act,
up,
also.
open up everything,
Yes,
which we would not like to
open this
put
up.
a pressure in the evening of your life.
I will put this as per this objection. That is we decided accordingly.
Mr. D.K. Dev, learned counsel for the petitioner, submits that he may be allowed to withdraw.
I will seek permission, less the chance may be given.
Huh?
Just I will seek permission from the client. If he want to withdraw,
Not
can I?
permission. You take instruction
Instructions.
and advise him. And she told this court that she's old enough. Otherwise, he would be, if we consider your certificate, he would be our age only.
Yes.
So
70,
another,
56, 54 years now.
hmm,
54 years, another 6 years will be there. So I will seek instructions from him.
better not to rebel all this thing. Because they try to find out the certificate which you obtain
Yes,
from which the schools which you have obtained records, there's a intimation that it was damaged, burned down in 1979, 80,
79 years.
Assam agitation. Then how could you obtain a certificate in 2006?
5.
5 is birth certificate.
By 5 is birth certificate and 6 is
School living
school
certificate.
living certificate
2006.
2006.
Then in that case, another
Another thing will come in.
case may. So advise him properly.
So I will seek instructions.
On the prayer of Mr. D.K. Dev, learned counsel for the petitioner. List this matter after 3 weeks,
After 3 weeks.
so as to enable him to obtain instruction from the petitioner. MSG at the Learned Edison. Senior government is present. Yes, next.
Next.
May I praise the Lord? Amen.
Yes.
In this case, my lord, basic prayer of the petitioner, my lord, there are two, my lord, writ petition, connected writ petition. One is by the petitioner individual, and in course of hearing, a question was put to me, why the other similar teachers not approach the court. Then under such circumstances, we filed a separate writ petition through association. This petition is by individual teachers. The
Second
passage-
petition.
First one.
First one is,
First one is individual.
no. Second was the individual.
Let me confirm. Yes, I'm sorry, madam. Second one is individual.
Of course,
Oh, yes.
first,
First one is a subsequent petition,
yes, first one is subsequent by
association.
same prayer,
Same prayer.
same grievance.
Same ditto on the same.
To back up the petitioners, individual petitioners.
Yes.
Your association has filed.
Yes, madam.
Any other new grounds?
No, nothing, madam.
New other grounds?
Same ground.
Then
same
in
period,
that
same-
case, we'll dispose of the 46602/2022
Madam.
as the same issue. We'll consider in the 151.
151. First, madam,
We'll
151
close
is-
this one then in that case.
Pardon, my lord?
Item 27 will close this. If there's no new pleadings or any other grievance.
My lord. Because, my lord, the item 51, my lord, they have, my lord, filed affidavit. Two affidavits. My lord, admitting our claim.
No, are you clear? Am I clear?
Lordship is absolutely clear,
What I'm saying is 151/2018,
my lord,
this is the individual
my lord. Individual writ petition.
writ petitioners. Persons.
All the 5%,
6%.
because they are also the members of the association.
So only for these 5%, 6%.
No, entire, my lord, teachers community. The association represent the entire, my lord, elementary education teachers,
So who are aggrieved? All the members.
all the members. All the members, because that was the question put to me, why they did not approach the court. You take over you think about the matter, then, my lord, under such circumstances, we have to file a petition by association. And we have made a statement,
Because by this petition 151,
my,
you had not only the petitioner, you attempted to expose the cause of the other members of the
yes, we have
the
also,
association.
we have also made a
So,
statement, similarly situated. person.
To
One may be, my lord, hard,
back up the deficiency.
My lord.
Deficiency, you have filed this 466.
as intended by the court. Court asked me, Honorable
Then,
Justice,
just wait. Whatever, do you have that as per the order 22/7?
That instruction is there,
Is there?
but this is a case where perhaps your lordships will come down very heavy.
Hmm.
It's an absolute abuse of the judicial process. There's a fraud played on the court, man. There's a collusion to the of the highest order. If I point out the fact, it is so atrocious that these kinds of things need to be nipped at the bud. What has been submitted by my learned friend? Perhaps not even the correct factual position. They are claiming areas on the basis of a document of the government of India. They had accepted the fifth pay commissions, the revision granted with effect of 90.
before my lord, senior, my lord, advocate general submits my lord, because he will project his case, and I will be in
I
big
should-
trouble.
Yes, I should hear you first.
Yes, he will
Because you have to
place his
petition.
case, then I will be, my lord, in big troubles to answer this question.
But sometimes we need to hear
Yes,
the
yes,
respondent first
Right,
to save your time and court's time.
because he is making, my lord, some allegation,
Yes,
and whether this
it's
allegation.
very
is wrong,
serious.
I understand.
Are you ready for that?
Yes, I'm ready.
Okay,
I'm
So-
ready.
you proceed.
I'm
You
ready.
have that instruction
Yes, yes,
Yes, yeah.
in writing. You have to
yes, yes.
bring on writing, in
Yes.
writing.
And perhaps court will not
Writing
go.
on the next date of listing.
Yes.
My lord, yeah.
In fact, my lord, this was in a different context, this perhaps will not even come into play
Yeah.
in the adjudication of the case.
Okay, then you proceed.
One similar education fraud is attributed to our client.
Which one you are studying?
I also 151.
151.
Yes.
Just give me 151.
Lordship, kindly, my lord, have a note that this is not a fresh writ petition. It's a continuation of earlier writ petition 21 of 2014. And first of all, I will refer to the notification which was challenged
Sir, what do you mean by continuation of 2014?
because
They're pending.
no, that was directed to be
It was
that disposed of with the direction to the authority, responding authority to consider our prayer. Then they rejected our representation on certain erroneous consideration, what we say, and subsequently we filed a second writ petition, 463. And at that stage, my lord, I was requested to appear. Fortunately or unfortunately, I appeared. And I, having gone through the writ petition, I thought the original order was not under challenge. Then I made a prayer before the court to give me liberty to withdraw and file a fresh writ petition. Liberty was granted to us, and accordingly we filed the present writ petition. Therefore, the grievance we have assailed in this writ petition is the grievance which we assailed in my first writ petition.
Yes.
Therefore, it is a continuous grievance. And my lord, what is the relief sought for? We are the teachers. Central government, my lord, 5th and 6th CPC, my lord, was introduced. Recommendation was made. Then as part of the, my lord, power exercise under the, my lord, Arunachal Pradesh adaptation of orders. 1987, they adopted, cabinet decision was taken, notification was issued that all teachers are to be given, my lord, the benefit of 5th and 6th CPC. Both.
5th and 6th together
Yes,
at a time.
yes.
Okay.
No, initially 5th, then 6th. Then we, my lord, approach the government. Then our claim is that we are entitled otherwise to back arrears salaries with effect from 1/4/98. There are two slabs. 1/4/98, my lord, up to, my lord, 31st March, 31st December 2005. Then second CPC 1/1/2006 to 31/3/2013. Then, my lord, a committee was constituted by the government, departmental committee. Departmental committee, my lord, on examination of all the relevant facts and relevant records, my lord, held that the claim of the petitioner, but at that point of time, we are represented by another association, ATA, Arunachal Pradesh Teachers Association. They say the claim is genuine. They suggested for payment of 4,64,000, 5,60,000. Then they referred the matter to a high power committee. High power committee also took a decision. The government has got some financial burden. Therefore, phase manner, you better pay. Then they, my lord, accepted that report. Then, my lord, there was total lapse on their part. We filed a writ petition. There is in 2014, notification was issued on 15/2/2013 by annexure B of the, my lord, writ petition number 151. Let me, my lord, refer to notification at page 60.
Page 60.
60. My lord, have a lordship got, my lord?
Yes.
The governor of Arunachal Pradesh is pleased to order for revision of refixation of pay scale of teachers. Also, teachers serving in government school of Arunachal Pradesh, as shown in the table. Last portion, my lord, bottom part, last part, one paragraph of from the bottom. The scale of pay for the aforesaid categories of employees will be notionally fixed from 5th CPC stage as adopted in the state, that is with effect from 1/4/1998, under the relevant rules and orders and actual financial benefits thereof. The however will be tenable from 2013, that is pay and allowances from month. What I understand from this notification that they fix the notional pay scale without any monetary benefit. That was our grievance. We are otherwise entitled to get the arrears salary with effect from 1/4/98.
That is your grievance.
That is our grievance, whether we are entitled or not.
Here also, here also.
Yeah, also. Same. Then, my lord, when we filed the writ petition, court did not examine our grievances. Court said it requires some examination by the government, so matter was referred to government.
Where's that, where's that order?
Yes. Order of the High Court.
Yes. Against this only, you have filed a writ petition. Earlier,
Yes,
you
yes.
filed a writ petition
Yes.
claiming that you should be given the
Benefit
arrears
of-
salaries
yes.
with effect from 01/04/1998,
My lord,
right?
my lord.
So what is that order?
95.
There's 95.
Yes.
Yes. Make appropriate representation before the so and so, so and so.
95.
Yes, yes, then
Heard Mr. So-and-so, so-and-so, so-and-so.
method by placing a speaking, what is the speaking order? That is
And then, my lord, Lordship, kindly come to, my lord,
page
next page,
96.
next page.
This 4th
Yes.
of October 2014.
Right, my lord.
So this is under challenge.
Answer.
Yes.
We,
What,
we challenge that
how you are
order.
agree?
Pardon, my lord?
What are the points you are agreed?
My lord, they say that financial crisis implication. My lord,
Just
Last-
read it.
my lord, pardon? My lord, I have some eyesight problem.
Okay.
Whereas a repetition was submitted by President CEC Atta Arunachal Teacher Association on 12/8/2009, requesting revision of pay scales of 80 lab assistant craft teachers, librarian, etc. of Arunachal Pradesh at par with the scale of primary teacher gradation scale under 5th and 6th CPC. And whereas the matter was continuously being examined by Department of Education in consultation with the stakeholder, including Atta, and while considering the issues mentioned in the representation, the Honorable Chief Minister Arunachal Pradesh directed to constitute a high power committee to examine the demand raised. And whereas department had worked out only area of pay involved on implementation of restructuring from 1/1/2006 to 31/7/2012 for an amount of rupees 35,16,85,425 and rupees 21,80,55,037 if implemented with effect from 1/1/2009 to 31/7/2012. And whereas the High Power Committee recommended for implementation of Government of India OM dated 4/4/2002 simultaneously in respect of ATS, craft teacher, etc. in the state of Arunachal Pradesh in totality. Committee further recommended for extension of benefit of national fixation of pay regulation of implementation of Part B pay scale to above mentioned categories of posts in Education Department and to negotiate with the teacher for the arrear as annual increment was calculated at rupees 6.10 crore on average of payment of the arrears in 25% in each financial year commencing from 2012-13 to 2015-16, subject to availability of budgetary provision. And whereas the recommendation of High Power Committee was submitted by number so dated 11/10/2012 to the government. And whereas the proposal was submitted to government for obtaining the approval of Cabinet and FD concurrence of the High Power Committee, the recommendation and Finance Department had given its concurrence on 5/1/2013 by UO number 2421 with retrospective effect on national basis from 1/4/98 to 31/3/13 and actual financial benefit with effect from 1/4/2013 onwards. Accordingly, government had issued notification by number so and so dated 15/2/13 revising pay scales of 80 craft teacher, etc., at par with central government norms and Part B giving benefit of national fixation regulation pay with effect from 1/4/98 to 31/3/13. And whereas considering the heavy financial implication on payment of arrear pay on account of implementation of higher scale, as per record, department convinced the ATA to forego the arrear of pay with effect from 1/4/98 to 31/3/2000. President of ATA accordingly submitted minutes of meeting of the association demanding arrear pay only with effect from 1/1/2006 to 21/9/2011. The revised pay as notified by government is now being enjoyed by the above mentioned employees with actual financial benefit on the regulated pay scale with effect from 1/4/2013 onwards, and no press representation from ATA was made. Therefore, it could be safely presumed that notification issued by government was accepted. And whereas subsequently another representation was submitted by association named APET.
Yes.
Therefore, my lord, from this order, it ipso facto appears that, my lord, the financial ground is the basic reason for rejecting our claim.
Obviously,
Therefore, my lord, I will say with reference to this particular order, whether this question was ever adjudicated by the court. I can refer two decisions on this point, and court was of the view, Supreme Court as well as our High Court. The financial ground cannot be the basis to, my lord, deny the, my lord, substantive right of the petitioner or the government employees. The right to receive salary is a part of their fundamental right, Article 21 and 300A. Therefore, simply because there is a financial,
your salary has not been denied.
salary not denied, but whether we are entitled to get the arrear salary.
Yes.
And lordship kindly to that extent, my lord, it will be hard for me. And that
Just because you have been granted the notional,
notional
it
means
doesn't mean that you'll get everything. What do you
I will
mean?
get everything, but
What do you mean by notional?
notional. Notional means, my lord, pay scale, my salary in higher pay scale without monetary benefits.
So,
Therefore, my lord, the period during which you were in service, it is not that we are not in service, we were in service. Therefore, the salary accrued during that period we are entitled. And my lord,
you show us how you are entitled.
Yes.
That's all. 99,
Niyam, volume to
98 to 2013. This is the period they are claiming.
Oh, কি করা?
Sir, before go to the law,
My lord.
you show us first how you are entitled. There's no dispute that notional,
Some, just a
not
minute.
notionally you have been the
কালকে একটা volume আছে না, তিনটা volume আছে না? কি করিস এটা? এটা হলো এইটা notification to
scale of had been fixed notionally,
Oh.
right?
yes.
As
Just
per
my lord, এটা নহয়।
from 5th CPC.
My lord, I'm just, my lord, just referring one notification. And unfortunately, that notification was not brought to the notice. 13 August 2009. I'm just reading, my lord. Kindly, my lord. Implementation of part 2 of pay scale of 6 Central Pay Commission for the teachers and nurses.
Is
That
it,
was the
bef- is it before this court?
Yes, yes.
Is it brought on record? Is
No,
it-
my lord,
has it-
we got the
has
notification.
it been, has it brought on record?
No, my lord, we got the notification, my lord, yesterday.
So
Yesterday.
will take up to 2 years. You filed that.
My lordship kindly have it because it is a part of record. Nobody can deny it. In line with implementation.
Sir, that's why I'm asking,
No,
is it
no,
a part of the
this-
record?
Part of court record.
Documents with the government.
My lord, in the line with implementation of part B. Part B includes education department and not staff of health department. During 5th pay commission, it has been decided that the proposal for part B under, my lord, 6th Central Pay Commission, revised pay scale of teachers, education department, nursing staff, so and so, is approved. It is already approved by the government. So what is the question, my lord, not to pay?
With effect from 1998.
Yes. This is the notification, 5th CPC,
By whom?
and by the Undersecretary, Finance. That apartment, or we have brought on record. The government approved, highest authority, so far as I understand, Law Department and AR, they approved. They arrived at a conclusion that claim of the petition is genuine.
Genuine.
Therefore, they should be paid 5,65,000. 5,64,000. These are the matter of facts. And somebody has filed affidavit. They say in their affidavit, the since government approved. Therefore, we are admitting the claim of the petitioner.
Approved.
Yes. They,
Is it an opinion or it's an approval?
no approval.
Who is the competent authority to approve?
Approval is law department.
Law department.
Yes.
Mr. Advocate General, if your law department is approved, pay them. What's there?
No, but that is the whole mischief. That is why I'm saying it is a, madam, the whole case is based on a fraud. And it is of such serious nature that we have initiated proceedings against 2 officers. And well, the seriousness I will just place.
Just will continue.
Yes.
My lord, did you take any action against this commissioner? Did you take any action against the secretary? Did you take any action against the joint secretary? What you have done? One nodal officer?
Where's that approval of the personnel and the law department?
Yes. I'm showing you.
Is approval or opinion?
Opinion. How can law department approve?
My lord, Lordship kindly come to my affidavit, additional affidavit dated yes. My lord, their affidavit, 18/10/2022.
1810.
Yes.
In writ petition 151.
No. Yes, in connection with 151.
Is it additional affidavit?
Yes.
Additional affidavit.
Additional they filed.
Filed by respondent number 4.
Yes. How can it be an opinion?
Where it is?
At page 13. Yes, 13.
13?
In their affidavit.
Is not 13.
Additional affidavit.
Additional affidavit.
Yes. Dated 18/10/2022.
It is. How many additional affidavit?
Number of.
So how do
Number.
find? I'm just holding one additional affidavit.
Number of.
Which one? You just kindly point out.
My lord, I'm referring, my lord, 18/10
By whom?
by the respondent.
You said there are numbers of additional affidavit filed by respondent number 4.
Reply affidavit against
Filed on 29 April.
filed on 18/10/2022.
1810, where it is. You find out. 1810.
Yes.
1810. Yes. 1810. Additional affidavit. In 466.
Yes. No,
No,
151.
151.
Just so. This 151. Additional affidavit.
This is written as a, my lord, the reply affidavit, my lord, it's wrongly written.
No. Reply affidavit against the redundant additional affidavit filed by us. That is the reply by this affidavit against the redundant.
Respondent as a reply affidavit.
Yes. We have prior to that, we have filed our affidavit bringing on record to the leave of the court.
So
So
which-
that particular notification.
Which you are relying, your reply or additional affidavit?
No, Lordship kindly, because number of affidavit, my lord. I may be puzzled, everyone is puzzled. My lord, Lordship kindly have a look, my affidavit, which I have filed as additional affidavit. Date on 11/7/2022.
Your reply or your additional affidavit?
My additional affidavit. Then they reply. But I have referred to 18/10/2022, that was the reply by them against this affidavit. They also admitted.
Yes, read it.
My. The draft parawise reply as attended by the department in writ petition number 151, Sri Nyajung Yano and versus State of Assam, State of Arunachal Pradesh, filed the Guwahati High Court, Itanagar Permanent Bench, regarding grant of payment of area sale to 5,64,000 for the period with effect from 1/4/98 to 31/7/2013 to the petitioner, who are regular employees working in education department as teachers and librarian in various schools in elementary education, has been with reference to amendments made in the writ petition, and the amendments appear appropriate. The department is now advised to fear the same and file the affidavit in opposition in consultation with the senior government advocate and submit the same before Honorable Guwahati High Court, Itanagar Permanent Bench, Naharlagun in time. Deputy Secretary Law, Director Litigation, Secretary Education, Law and Judicial Department, everybody has not come to sign. Now they are saying it is fake. Enough,
Yeah,
enough.
is it there?
Enough.
We're not able to locate this. It's a office law. Accepting the Peral's reply, what's there? How can you rely on this?
My lord. And what is their reply to the scheme? What is their reply? Now have a look. My lord, I have already referred to 18/10/2000.
This is office law. Normal procedure of accepting the Peral's comment in your writ petition. What is this?
And it was, my lord, it was countersigned by law department.
Doesn't matter. What is this? Sorry, sir. Don't place unnecessary documents. This is office noting, file noting,
I, my lord, I don't think.
not
that-
even a letter also. It's a file noting.
Then what about the 2019 approval?
What 2009?
I have already placed, my lord, I have referred to your lordship,
Which one?
notification.
Which one? Which notification?
Yes, I have given your lordship.
Which one? That I have given it back.
Will photo please. Did they ever say, my lord, it is a paravoice comment? What is their reply in their reply affidavit, my lord?
Forget about that. First you establish what is your right to claim from 1998. That's all. Why you're relying on all those office note? What is this? File noting.
My lord,
Whereby this when the law department has agreed to fair the draft Peral's comment. That's all. It's a normal file noting.
if it is
You
a
cannot
file,
rely on it.
if it is a file noting.
Even it's not an opinion at all.
Well, if it is a file noting, then what was, my lord, the reply of the
Forget
respondent?
about that.
Did they ever, my lord?
First
forget
you
of-
establish how you are entitled from 1998. Just so us. Would
Then
allow the writ petition right now.
Lordship kindly see.
If not dismissed,
No, Lordship cannot dismiss in that way.
then
Cannot.
you show us. Don't, sir, don't place unnecessary documents.
If I, my lord, don't allow to rely on documents, now how can I?
It's
make my
this,
assumption?
it's not, I just want, this code, what you place on the documents
This
or show us
My
on
lord,
what basis you are claiming,
my lord, 13
how you are entitled.
13 August 2009.
Yes.
That is a notification I have, my lord, placed on, I referred to pass, I have passed it on, my lordship.
Then
I've gone through.
Give it back.
Yes.
That your lordship will not allow this hearing stage, my lord, without placing it on record.
There is a
We are-
technical.
We are being taken by surprise. How can
No,
he?
no, it is a absolute
No, no,
technical.
it's page 12 in the affidavit, reply affidavit
Yes,
filed against the rejoinder additional
Yes.
affidavit filed by the.
No, he is
petitioner.
relying on some other document.
no. Oh, my lord, I am referring to a
The
notification.
department is now advised to fare the same and file the affidavit of the
Yes.
consultation with senior government. This is
Everybody has
page
committed,
12.
everybody has committed foul.
Just because the director litigation or the secretary law or education
Yes,
has agreed to the draft whereas reply,
yes.
can you derive the right from that?
Then what about this notification?
Which
Am I not entitled to rely on this
which is
notification?
notification?
That is, my lord.
That is not placed before me.
Then I'll file
It's not
affidavit.
brought on record.
I'll file affidavit. I'll file affidavit. But nobody can ignore this notification. This is notification. issued
Sir,
by
I'll
government.
impose a cost. You could have the sought for the prayer at the initial
Madam,
stage. We have spent
I-
around 45 minutes.
No, I think, my lord, my Advocate General will appreciate. This is a mere technical, and I thought that he will never raise any objection. That's why
I'm being taken by surprise and he said, I will not raise objection.
otherwise court is to dispense with justice. And if it appears to the court that this document is absolutely relevant, then some opportunity be given to us.
Let me have a look. Hopefully, it's not an opinion of undersecretary.
It's not a notification at all. Can you see the language? Approved.
Part B, pay scale of 6 Central Pay Commission teachers in legislature. This is again by Undersecretary Finance.
Yes.
And it is not even pertaining to fifth pay commission. If I have
Yes,
heard him correctly, it pertains to sixth pay commission.
Yes.
Which is not even an issue in this.
Yes, yes,
retribution.
it's the issue, fifth and sixth, both.
fifth also you,
You say it is not a part of record.
yes, fifth you didn't, sixth you didn't get. Sixth pay commission,
No, fifth and sixth,
no, as per sixth pay commission, have you got?
nothing.
Have you not?
We didn't get at a single penny, madam.
Sixth pay is from which year?
Six pays from 1/1/2006 to 31/3/2013.
2006 to
13.
13.
How can we, my lord, how can we anticipate that government will raise this question? And of course, my lord, I ought to have made a prayer at the outset. This is a notification I received. That notification is nothing but an approval. And by virtue of this approval, we are entitled.
What is to be done?
Unless he brings it on record, we cannot even respond, madam.
He's heavily relying on this now.
Without
Any other apart from this?
Any other appointment, then the my lord, kindly, their own.
Assuming that you did not have this, had you not have this copy, this notification,
Yes, I have.
what are the other grounds? Let us.
Yes. Other ground, kindly, may I see the committee which was constituted by the government at page 64.
Writ petition.
Yes. Lordship may come to page 65. Para 6. The committee examined the case as per records available. Have you lordship got, madam? Para 6. Committee examined the cases as per the records available and has come to the conclusion that claim of ATA, earlier association, or the categories of employees, are genuine. It is their own report, they constitute the body. Committee has arrived at the conclusion.
But it's not binding on the government.
Madam, it is your committee.
Yes.
Doctrine of estimate will come. And what is the reason that we cannot accept this, my lord, opinion of the committee?
This is opinion, maybe it's not binding on the government.
Then, my lord,
Then read 7, para 7.
Para 7. Para 7.
Yes.
ATA has earlier, apa? ATA.
ATS earlier announced claim against the area up to 31/12/2005. Commissioner and Secretary Education is
Last
direct-
year, the Commissioner and Secretary negotiated with the members of the ATA on this account also, and he has reported that the ATA would agree to payment areas in phased manner in 4 phases.
4 phases.
Yes. Then, para 8.
Whereas therefore, the committee after
Extend the benefit of notional fixation re-regularization immediately, negotiated with teachers to the areas as the amount involved will be huge. Pay the areas in 4 phases, so and so, so and so,
pay the area in 4 tranches.
subject to proper projection and fund availability. Employees retiring the terminal year can be received full payment of areas. Has it been implemented, accepted by the government? No.
Government. Therefore, my lord, in terms of this,
If it is not accepted, what's wrong?
then Lord
It's
should
not
kindly,
binding.
then Lord should kindly come to next report. There is the High Power Committee, which was already referred to by Chief Minister, constituted that, my lord, High Power Committee.
Hmm.
High Power Committee, then my lord, Lordship may come to page 69. Area benefits from 1/4, have a lordship, at page 69. 1,
Yes.
2, 3, 4, 5 from bottom. Area benefits from 1/4/98 to 31/4
Surrendered by the
12,
services.
5 have already been surrendered by the service evocation affected groups ATA by communication details also. Category was strength. Then, madam, next page. The listed category of employee who had been deprived of appropriate scale of pay during 5th pay commission, pay revision, so and so, and hence an inappropriate fixation of 6th pay commission of the state government may consider for regulation of their scale on amount basis, on notional basis, from 1/4/2008 to 31/12/2008, as recommended by HPC in view of the estimated financial implication indicated in the preceding paragraph. Then, my lord, pay arrears on refixation regulation in 4 branches at the rate of 25% during 12, 13, and 14, 12, 14, and 15, 15 and 16, subject to fund availability. High Power Committee recommended at the rate of 24%, my lord, you pay the arrears year-wise.
Whatever 2006 to 2013,
My lord, they did not.
Getting everything. This is all an afterthought. That is why I'm saying, may I quickly, briefly place the
My
fact?
lord, can they show? Other day also my respected advocate general made a submission before we got everything. Can they place on record? We'll withdraw the writ petition that everything was paid to us. So far the area salary is concerned, madam.
No, area, that is why my friend is not placing the main order, impugned order, but besides that, may I briefly indicate? They got their 5th pay commission revision with effect from 1/1/96. There was a notification by the government of India ultimately, in 2013, after, your lordship has noticed, the education commissioner negotiated with them that we cannot give you, it is impossible, because the total implication will come to around 200-300 crores. we will, all right, what is meant for the union territories, we'll give you that further benefit, but prospectively with effect of 2013. They accepted it. 2000, thereafter, writ petition was filed. This honorable court directed that you simply consider the case pass as speaking order. The speaking order was passed in 2014. They keep quiet. Suddenly they wake up in 2018.
No.
They filed,
No, my lord, it is not correct.
Okay.
We filed second writ petition, that was withdrawn.
whatever, it was withdrawn. So this writ petition by 6 persons got filed in 2018. They say that you give us with effect from 1998. The mischief starts there. These 6 persons get together to file a writ petition. One of the interested parties who, unfortunately for the government, he was functioning as a nodal officer law for the education department. He prevails upon everyone, gets the director to file multiple 2-3 affidavits without approval of the authorities, the government. Of his own, they file affidavits admitting it. Later on, it comes to the notice of the government that all this mischief has been played. So immediately disciplinary proceeding was initiated against that nodal officer and also the director. And finally, an affidavit, detailed affidavit was filed narrating the entire correct factual position. And these people are facing proceedings. Almost it is nearing conclusion. Based on those affidavits where they admitted the entire claim has been made. Now, once these affidavits, false affidavits were filed, the association wakes up, realizes that based on these admissions, only these 6 persons will get it. So, in 2022, the association files the second writ petition, which is item number 27 before your law. So, with time, with all these manipulation of records, they keep on getting wiser, and an order, speaking order passed in 2014 is challenged in 2022. In a nutshell, that is the fact. And your lordship, can you come to the prayer? Is this writ petition even maintainable? It should be, in my respectful submission, the only thing that is required to be decided is how much cost your lordship will impose on this petitioner. There's no other issue to be adjudicated in this case. Page 54, your lordship will come to the prayer C. As to why the impugned minutes of the meeting, CAC, of Arunachal Teachers Association, held on 21/9/2011, should not be set aside. How is this writ petition maintainable? This is a private body. So why they are challenging this is this association had accepted the position. So therefore they dissolve this association, form a new association, file a fresh. Absolute abuse of the judicial process.
What is the other part of the relief?
On this prayer itself, both these writ petitions should be dismissed as not maintainable. How is a writ petition maintainable against a private body?
Other part of the relief? There are other part of the relief.
Absolute, my lord, as I said, absolute abuse of the judicial process, and your lordships will come down very heavily on such petition.
It's okay, we'll consider the other prayer. What is the other prayers?
The other prayers are, they are asking for setting aside.
Implement this recommendation 5th pay or provide the arrears salary for the period 19 to none. They are asking only 5th pay.
Fifth pay they have already got. That is the instruction that was sought by the honorable court on the last occasion, and we have indicated in that instruction, if your lordship sees that instruction, they got it from 1996. They are asking for a further benefit, which was meant for. May I place the document, madam? That will make the position very clear. कहाँ है वो दूसरा वाला reputation में था ना दूसरा फाइल देना मेरा वाला फाइल.
But then you have already said that this will be scale of pay will be fixed.
They have
notionally without financial
exactly
benefit.
exactly we have given them the benefit. If your lordship kindly comes.
No, see, 5th pay commission, you have decided that there will be the scale of pay shall be notionally fixed without financial benefit.
No, that is the second. If your lordship will have the second repetition for a moment. That is 466. Yes. And your lordship will kindly straight away come to page 128.
128.
Yes. they were already getting the benefit of fifth pay commission. Now, this letter, it's a Government of India letter addressed to, if your lordship.
No,
see,
which one?
Page 128,
Read.
uh,
Affidavit filed by the.
affidavit filed by the respondent.
3, 4 and 5. State.
It is an affidavit filed by the respondent number 3, 4 and 5. 1, 4 and 5. Perhaps your lordship may like to continue at 2 o'clock.
This is additional affidavit.
No, this is a affidavit in opposition by 1, 4 and 5. It's a,
Affidavit in reply. Affidavit in.
it's a bulky document.
Yes. Yeah, this one. Continue it to.
One.
My lord, I'm a senior medical officer, my lord,
Yes.
senior grade, and I have been attached there at Kolkata DRSC, DRCS. And actually, my present place of posting is Pasigat. From there, I have been attached there at DRC, Kolkata, from the year 2019. And till that, I am serving there. Now, while serving there, my lord, I brought down my son also, who is now facing his class 10 examination. He's now studying in Calcutta. So his examination will be completed by March 2025. And moreover, my lord, after my attachment there at Calcutta, I have obtained a post-graduation diploma in family medicine. It's a course of 2 years, my lord. I have completed the first part, my lord. I have cleared the first year, and my second year will be completed by the June June of 2025. Therefore, my lord, now I have
You
now
obtained the leave,
no, my lord.
study leave.
No, my lord.
Then how can you pursue a course?
My lord, since I am serving there, my lord. So, my lord, that is not only the
You are
ground, my lord.
liable for disciplinary proceedings.
My lord, in
How
fact,
can you pursue a course?
I have in,
Even if you are, if you
before-
don't have a
before
work
I joined, my
practically,
lord. Before,
legally you are not supposed to.
before I joined, my lord, I have intimated the authority, my lord.
Intimation is not enough. You have to be granted.
Now, my lord, that is only
You are
not my ground, my lord.
illegally pursuing.
My,
You are
my,
liable for disciplinary proceeding. We'll direct them.
my lord may kindly appreciate
Where is the impugn order?
the impugn order is that, my
Page
lord,
21.
page number
21.
yes, yes, my lord.
It's a common transfer order.
Yes, my lord.
Huh?
My, yes, my lord. My lord, I understand, my lord. Since I am the government employee, my lord, transfer and posting, my lord, this is the instead of this of the service, my lord. I am not claiming that, my lord, I should be retained there for a year or more than that, my lord. Only my prayer is that, my lord, my son, who is pursuing class 10 examination, he is
You consider
at
this case.
Calcutta. Let the examination of my son be finished, my lord. Otherwise, if I have to move from Calcutta, my lord, he is to be also brought with me. In the middle of the session, my lord, the
We'll
economic,
direct them to consider your representation.
my lord,
That you are taking a risk by placing all this.
postgraduate diploma, serious matter.
It has come to the notice of the learned standing council.
My lord,
Have you mentioned in your
yes, that mentioned in representation itself. Yes,
you are inviting
yes,
risk
I have mentioned, my lord. Now, besides that, my lord,
vulnerable to
another
disciplinary
ground, my lord.
proceedings.
Another ground, my lord, may kindly favorably be considered, my lord, because I feel like, my lord, the petitioner
the only
deserves
ground.
some sympathy, my
That's the
lord,
only
from this
ground.
honorable court. Not only that, my lord, my husband, my lord, he underwent a surgery, my
These
lord.
are all hardship, family hardship.
Yes, my lord. And he is also now posted to Orissa, my lord. Orissa and Kolkata is just nearby, my lord. So while there being at in Kolkata, my lord, I can attend my ailing husband
There's
also.
no, there's no problem in communication nowadays. You can directly go to.
That is
from-
true, true, my lord. But in Calcutta and Orissa being the bordering state, my lord, I can, within 5 hours, my lord.
Any
Yes.
other ground?
That's, and more, and my lord, there is a, but I will not harping on this law notification, my lord. There is a notification, my lord, issued by the state government and the central government, my lord.
For what?
Transfer has to be effected by the end of this April. And in the mid of this academic session,
The
transfer
common
should
transfer
not be.
order, you are a doctor,
Yes, my lord. I am a doctor, my lord, senior medical officer.
what is your attachment? to
attachment,
Calcutta?
my lord? Will find it. Page number
20.
20. Yes,
20.
yes, my lord.
We'll dispose it of.
Yes, my lord, at least with a direction that my lord, since my lord, my this son's educational career is this at risk now, my lord. Let-
We'll direct respondent authority to ensure that your son's study is not hampered.
Yes, my lord. That will not be hampered when I will be here for at least this
He's in college.
next 6 months. Yeah.
College,
No, in class 10, my lord. He'll
Class
be
10.
appearing CBSE exam this year, my lord. It is-
your that residence or the quarter, whatever is Calcutta, they'll retain it for your son.
My lord may not do that, my lord. My lord may kindly allow the petitioner to stay there for another 6 months, my
That I
lord.
cannot.
That
It's very difficult.
after that, my lord, as I have fairly submitted, my
So you
lord.
come back if they don't consider it. We'll see. First, representation.
My lord, that may again,
Otherwise, there's no ground to interfere. 2019, you are there. 2019.
that is true, my lord. That is why, my lord, I am fairly submitting, my lord. I do not have the right in the divisible right to
Yes.
be there, my lord.
So that will
Only-
be, that
only-
will be considered by authority only. Family hardship and other things. Or Mr. D come to learned counsel for the petitioner. And also had Mr. Titagu, learned standing counsel for what, health department or
Yes,
what?
health and family welfare, madam.
Health and Family Welfare Department, Government of Arunachal Pradesh. For all the respondents,
Yes, madam.
next paragraph, by filing this petition, no, before that. Considering that the challenge made in this writ petition is to the transfer order dated 2008-2024. The petition, writ petition is disposed of at the motion stage. Next paragraph. By filing this writ petition, the petitioner has put to challenge the order number page 21, number so and so dated 20/08/2024. Waiver issued by the Commissioner within bracket Health and Family Welfare bracket Government of Arunachal Pradesh. Whereby as many as 31 GDMOs within bracket allopathic bracket close are transferred, including the petitioner. the next paragraph. The petitioner is serving as GDMO within bracket.
No,
What
my
is-
lord.
What is your post?
Yes, he's, in Pasighat, my lord, he's serving as joint director, my lord.
MO, you are MO. Next paragraph. The petitioner is serving as
Yes, ma'am.
medical officer, comma, BPGH, comma, Pasighat, who has been attached at DRC office, comma, Kolkata, West Bengal, by order dated 23/07/2019. Please note. Next paragraph. Mr. D. Kamdu. Mr. D. Kamdu, counsel for the petitioner, contended that nominally as per the guidelines for transparent posting in the state of Arunachal Pradesh is issued in the month of April. In the
Yes,
month of
yes,
April.
yes, my lord.
Mr. However, the impute order has been issued in the month of August, which is in violation of the said guidelines. Mr. He further submits that on being attached at DRC office, comma, Calcutta, comma, the petitioner has brought his son and got him admitted, son,
Yes, son, yes, ma'am.
got him admitted. He or she,
He, my lord.
okay, brought his son and admitted him the school, who is studying in class 10,
Yes, my lord.
and his board exam would be in the month of March 2025. By transparent posting guideline, whatever it would say, yes, transparent posting guidelines, by circular dated 02/06/1998, and amended from time to time on top, in the beginning. Essentially, the challenge. Next one, No, continue. If at this stage, if the transfer order is given effect to in respect of the petitioner, the study, the academic career of the son of the petitioner would be hampered. Therefore, he submits that the petitioner be a direction may be issued to the correspondent authorities to allow the petitioner to continue till March 2025.
Yes, my lord, till
Just before the last line, he further submits that the wife of the petitioner,
No, my lord, husband of the petitioner.
that's why I was asking that, then in that case, he, wherever
I was of the
for the
impression that
petitioner as you just said. The further submits that the husband of the petitioner is also posted in the state of Orissa.
yes, my lord, which is very nearby Kolkata.
Near to Calcutta, where the petitioner can have a, can and easily visit her husband. Then therefore, so and so. Next paragraph. Essentially, the grounds of challenge is on the is to the effect of personal hardships as well as to her family. Next paragraph. The petitioner has also filed, the petitioner appears to have filed a representation placing out the grounds and the hardship faced by her before to the Secretary, Health and Family Welfare, Government of Arunachal Pradesh. Next paragraph. Considering the facts and circumstances of the, no, having considered the facts and circumstances, I'm of the view that this writ petition can be disposed of. And this writ petition, I deem it appropriate to dispose of this writ petition, with a direction to the respondent authorities, particularly Commissioner or Secretary.
It should be
Issued by whom? Commissioner.
Commissioner.
Commissioner within bracket. Health and Family Welfare, Government of Arunachal Pradesh, to dispose of the representation. Which one?
My lord, I have made two representation, my lord. One is to director and another is commissioner.
Secretary,
So
secretary.
yes,
54.
30/08/2024. Accordingly, the writ petition is disposed of. Next one, disposed of to the respondent authorities, particularly the Commissioner, Health and Family Welfare, Government of Arunachal Pradesh, to consider the disposal of the representation that is so and so, within a period of 15 days, 30 days.
30 days. 15 days.
let it be 30 days, my lord. My lord may also allow the petitioner to file press representation, my lord, because in this representation, my lord.
No, in that case, you will have to write to consider and dispose of references. Please stop. Having noticed that the next representation is addressed to the Secretary, Health and Family Welfare, the petitioner is directed to file a fresh representation before the Commissioner so and so. Within 2 days.
Well, my lord, petitioner is in Calcutta, has just moved this morning after swearing of the affidavit, my lord.
Within 5 days.
5 days, my lord.
5 days from today. Please stop. On that's a representation, on receipt of the representation from the Commissioner, Health and Family Welfare shall consider and dispose of the representation within a period of 20 days thereafter.
Yes. My lord,
till
till then, my lord.
till the representation is disposed of. Come on. The impute order in respect of so and so, in respect of the petitioner, namely so and so, shall not be given effect to.
Much obliged.
There is no kind of reliever and all.
No, my lord, that is why, my lord, that
Okay.
there is no kind of reliever, there is no this, this, this,
Writ petition is still disposed of. In terms
much
of-
obliged.
Huh? I think,
Lord,
if
at the
he's
outset-
raising, if since you are, I mean,
Notification.
banking on this office memorandum,
My,
we'll allow you to file,
my,
we'll keep it part hard,
my business,
all right?
my. I'm obliged.
And he should give us reasonably well ahead so that we can respond if necessary.
No, within 1 week,
Within
by furnishing the copy to the,
copy, my lord, I will go back, I will prepare, then I will send. So, my lord, 2 weeks.
because it should be before the next date, they should be ready,
Yes.
if any
If
affidavit they
necessary,
want.
we'll file a reply to.
So we'll give 10 days time.
Fine, fine.
But obviously you'll have to
Fine,
furnish.
fine. I'm
And
obliged.
then thereafter we'll fix the
Fine.
date after 3
Fine.
weeks.
Fine.
Huh?
I'm obliged.
Heard, Mr. A.K. Prokest, learned senior counsel assisted by Mr.
My lord, in fact, I am not this designated, my lord. So, I'm not designated.
It's not designated, you have not been designated.
No.
Is it?
Yes.
Okay. Learned counsel for the petitioner. And Mr. I. Chaudhary, learned advocate general. Assisted by Mr. T. Tagore, learned standing counsel for the state respondents. Come on. After- Hearing the matter.
Immediately.
That's similar-
reply to
some length.
the-
At some length, come on. It is noticed that the petitioner has relied on an office memorandum dated 13/08/2009. By placing before this court. This court. However, same has not been brought on record. Please note. The Mr. A.K. Prokest, learned counsel. Press for an is granted further 10 days time, granted 10 days time to file affidavit to bring on record the office memorandum dated 13/08/2009. The petitioner, the learned counsel for the petitioner to furnish the copy of the additional affidavit. Mr. Copy of the additional affidavit, which would be filed during, within 10 days. Mr. The respondents may file their response on or before the next date fixed. Let the matter be remain part heard.
Yes.
List after 3 weeks.
Your Lordship, The division bench matter is fixed on 24th, your lordship may fix it on that day, same day.
24th will be 10 days.
10 days will be completed on 19th, today is 9th. So that way we get 4 days in between to file the response.
Then let us make it 25. 25 is not holiday.
It's open, but I will get stuck for too long.
That is some of the petition.
It is so,
That is some of the petition. By the time I will, within 10 days, I will file the copy with an advance copy to him.
Then we won't know the bench position.
then we'll not keep it partner in
No,
that case,
keep it
after
partner.
vacation.
I have no problem, madam, because.
No, after
24
vacation, we will not keep it up partner. Because we have spent
Roster is,
a
my
considerable amount of time.
Madam. Then lordship
At
may,
least 1 hour we have spent, so
Madam.
we have.
lordship may fix it on 24th itself. After
23rd.
23rd or the first week of October,
In that case, my lord, 1st of October,
1st of October,
Yes.
it's a Tuesday.
Madam.
1st of October.
Madam.
No.
Lord, I may be allowed to take back my lord.
Yes.
Alberta. Obliged, your lord.
ये तो हम लोग का, ये रख लो.
Thank you.
Item number 29.
Twenty-nine. What is this? Sir,
Now, here in the petition, there are 33 petitioners, and they are from different villages. That is from Nari, Seren, and Palm, Old Decca, New Seren, Telam, and New Telam. All the petitioners. Now, there is a scheme and proposal to erect transmission line.
it's a forest, reserve forest.
Huh?
It's a reserve forest.
Now,
What is that notification? 1975.
1975 notification is page number page number
50.
50 and
How you
type
can
type
challenge
of
that?
copy is 52.
How you can, what is the ground? Are you challenging this?
Yes. This is the preliminary notification. This is not the final notification. This has not been issued in the section 17 of the Assam Forest Manual. It was issued as per section 5 of the Assam Forest Manual Act. Then it was issued in 1975, whereas we were in that area since 1920. Now, an order which was passed by political officer Abor Hills, Pasigar, that is in page 56, and type out copy is page 57. See, the Serengam Tasat Doe has died. His brother Taseng Appeal Taseng will arrange to pay poll tax for the present and also act as a gum until his village have differently decided who should be gum. Now, it was issued, this letter was passed, or order was passed on 11 May 1948.
Where is the final notification?
No final notification. That's why what my contention is that until and unless when there is no final notification, it cannot be treated as a
Reserve forest.
reserve forest. Now, why it is no final notification was not done? There is also, I have annexed the document. 1988, there was an inquiry. Annexer 7 page 99. Come to the page 99.
99.
99.
Settlement proceeding of proposed Dekaru Dekar Reserve.
Yes.
It continues to reserve.
Yes. In continuation to this office letter, such 9. In view of above, I would suggest that the final settlement of the proposal of Decca Reserve Forest may kindly be kept in abeyance. Yes, we are not disputing about the issue of the preliminary notification. Upon the preliminary notification, then there was an inquiry made by the forest settlement officer. When there was a proposal, that there is no sufficient area to cultivate for cultivation. In that case, the people of those who are in Dipa, those who are in Seren, Telam, Nari, there was a proposal to accommodate them in the Galleria forest. But that Galleria forest now become Assam. So because of this socio-economic and socio-political problem, this preliminary notification, though it was issued in 1945, it cannot be come into enforce and it did not become effective. Therefore, it becomes impractical. But
Strongly often, if some land in the plain gully area is provided to them as per insurance commitments to ensure the I would suggest that the final settlement of the proposal may kindly be kept in abeyance. Yes, there
yes, yes. Now, there is a clear provision written in Section 70, Section 11, Section 9 for the power and function and procedure which are to be adopted in as per the Assam Forest Manual by the Forest Settlement Officer. But here in the case, they have not done nothing, and it delayed for around 49 years now. So people of present generation, they are not known that this area has been kept in a reserve forest. But suddenly, when they wanted to, the Power Grid Corporations of India, they tried to install.
It's okay. So according to them, it's under reserve forest.
Yeah.
Therefore, you are not entitled for compensation.
Yes, that
Yes.
is. So my contention is that
Yes, it's that.
it is not a reserve forest.
No, my lord,
As per your,
My contention is that it is not a reserve
it has not been reserved. There was a proceedings initiated, but it has not been brought to a logical conclusion.
Yes.
Therefore, it's not a reserve forest. at
It
all.
is not a reserve forest.
The procedure has not been completed. The requirement of the proceedings have not been completed.
Yes, and
That is
for
admitted.
49 years.
that is,
That is admitted, then land
Lord.
belongs to whom?
my lord, that is admitted.
Land belongs to whom?
Land belongs to us, the petitioners.
Then
My lord, that is admitted, but what under the Forest Conservation Act, my lord, it says any forest, either reserve forest or other forest, private forest also. Any forest which is going to be diverted for non-forestry purpose, the permission, the approval of the ministry is required.
it has been done.
My lord, that approval is being done by. Now the approval, when the approval is given, my lord, then the user agency has to deposit to the forest department the compensatory afforestation, everything like that. Now that is okay.
That is
Different issue. Now, the main issue is that now whether the compensation can be taken by the forest department or should it be taken by the private landowners? This is only the issue.
No.
Because Supreme Court has said private forest also will come under the definition of forest. Even by now, there is a 2023 amendment where in the amendment, any forest, irrespective of whether it's a reserve forest or not, if it was in the record of the government before 1996 as a forest, my lord, then also it will have to come under the purview of the Forest Conservation Act. That is, so whether it's a private forest, only the thing under the Forest Conservation Act is required is you'll have to take prior approval for for conversion of your forest, your own forest, for non-forestry purpose. That is forest. As of the judgments which have gone, which the forest department is relying, is only the definition of forest. But nowhere it has said that the compensation for that forest has to be paid to the forest department, or there is nothing as such saying that private owners will be entitled to the. My lord will examine this, whether who will be entitled, the forest department or the landowners.
Landowners only.
Yes, my lord. So, my lord, this is as per the.
If they can establish that they are the owners of the land.
Yes, my lord. My lord, in our affidavit,
Yes.
we have basically not. We have basically affidavit of the forest department, respondent number 7 and 8. We have basically justified what is forest land only, relying on the
Respondent number
7 and 8.
additional. Again, these are all additional affidavit.
My lord, this is affidavit in opposition.
Yes, 7 and 8.
Yes, ma'am.
Yes.
It is by the forest department.
Yes, pass the number of orders, it will be for the. It's okay.
Yes, my lord, relying on the various judgments of the apex court, how the apex court has defined forest land to include even the private
Status
forest.
of land proposed for declaring reserve forest remains forest land.
We have annexed
Has it been executed?
My lord,
Has it been executed?
this preliminary notification,
No, no.
this, it's,
This construction of cable line.
no, my lord, it is being executed in some portion, but it has been told, I'm told that in this stretch where the petitioners claim rights over that. My lord, in short, what we have
Lordship, I beg to intervene, Lordship. I am for respondent 9 and 10, the executants of the project. Lordship, the work is ongoing and the exact decree as to where the work has reached. If Lordship pleases, we will file an affidavit to bring on record the current status of the progress of the construction work, Lordship.
Okay, it's hearing stage. We're hearing the matter finally.
Lordship.
Now,
We're hearing the matter finally. I'm just asking.
now, my lord, here it is undisputed. It is not a reserve forest. There might have been a preliminary notification, but it has not culminated to a final notification. So it is still not a reserve forest. However, the status still remains as a forest land, my lord, because when the preliminary notification was issued, it was a forest land, therefore it was, there were forests, so it was forest land, which was to be
Are you
notified.
admitting that they are the landowners, or are you disputing?
The landowners, we cannot admit. We are admitting only the fact that it is not a reserve forest. We are still saying that it's a forest land because till now the forest exists, and since it was under the record of the government that it is a forest land, although it was not a reserve forest, it was a forest land. So the definition of forest will continue. For that matter,
So
any
according to you, if it's a,
if it is diverted,
if it's a forest, no, there cannot be any private owner.
no, my lord, there can be.
Then
There can be. So the interest of the forest department is that the procedure for diversion has to be applied and the required compensatory afforestation, all this has to be paid by the user agency, so and other charges. Now,
that will be different.
yes, that is
The
different.
Compensation for the land is to be paid to the
Yes, my lord.
landowners only.
Yes, my lord. Now coming to, I'll take your lordship to one document by in the affidavit of the respondent number 10, and they also don't deny that what the respondent number 9 and 10 says that under if it is a reserve forest, my lord, will
Yes.
kindly come to page 108, annexure 12.
108.
Even if it is a reserve forest, what they are saying,
108. Notification.
yes, my lord. Even if it is a case where this falls under a reserve forest, then also there is a special ex gratia relief package. But this is for reserve forest, madam. The user agency are saying that it is for reserve forest.
So you are admitting that it's not a reserve forest.
Yes, my lord.
Yes.
Yes,
But then it falls under the
forest,
definition of forest.
forest.
So you have the forest has the right, and accordingly you have
Clearance has been given,
clearance for diversion.
diversion has been given.
For this purpose.
Yes, and there has been, it has been directed to the user agency to deposit the amount for compensatory afforestation, etc. These are done. Now, even if it is a reserve forest, there also where people have rights over the reserve forest under the right scheduled tribe and other forest dwellers act, 2006, they will also get compensation under this 2023 notification.
Here, 23,
Yes, this is 31st August 2023.
not the compensation under the Lara Act.
No, madam. Lara Act is totally because the power grid, they do not acquire land. They only give the value towards diminution value of land under the by following the Electricity Act and the Telegraph Act, madam. There is there. Here,
There's no acquisition.
no acquisition as such. There is a notification. I'll provide my lord with regard to this. So with this, my lord, a clarification has also been given by the Land Management Department at page 103.
Yes.
Guidelines regarding payment of compensation to forest dwellers, private owners in the transmission line right of way through unclassified state forest, my lord. This is exactly the situation of the petitioners here. It is unclassified state forest, my lord. Although it's not a reserve forest, it will come under unclassified state forest. Here, my lord, the Department of Land Management, Government of Arunachal Pradesh has issued circular number so-and-so dated 1/6/2018 to all Deputy Commissioners of Arunachal Pradesh conveying the decision of the Cabinet on modalities for payment of land compensation to be made to the individuals community for the land to be acquired in unclassified state forest areas as per assessment done by the collectors based on the district rate notified by state government from time to time. It is explicitly mentioned that the land compensation is must for acquisition of land termed as Jum land in local language and extinguishment of rights in USF area. A copy of circular so-and-so. In the background of the above, it is to clarify that the notification by the government, the Department of Power, white number so-and-so 29/8/2019, read with circular number so-and-so 1/6/2018 for determination of compensation shall be applicable for acquisition of land for transmission lines passing through USF areas. Further, this it is clarified that while assessing the compensation for loss of so-and-so, so-and-so. Now, my lord, here also, even if it is a forest land, it comes, if it is not reserve, it comes under the unclassified state forest. So the notification issued by the Power Department will be applicable. This is notification.
It is while assessing the compensation for loss of rights and privileges.
Yes. Notification
policy, value of individual forest trees in USF will not be included.
Yes. That is for if it is in the RRR. Here it says notification of the Power Department so and so shall be applicable for determining the this. This is the notification 29 that has been referred.
Transmission.
This is the Governor of Arunachal Pradesh is pleased to adopt and notify the following rates for payment of compensation towards damages in regards to right of way for transmission line in accordance with the guidelines of Ministry of Power so and so dated 15/10/2015 for maintaining uniformity in compensation payment to affected landowners during construction of transmission line. It has been decided that similar payment method towards compensations shall also be adopted in the state of Arunachal Pradesh. These guidelines of payment methodology of compensation towards damages as stipulated in section 67 and 68 of the Electricity Act read as so and so. Here it provides for 85.
Any assessment? No.
assessment or the assessment, what has been made was by the Forest Department under the Forest Conservation Act for a forest compulsory afforestation. Yes, my lord. Now, they are preparing as per this. They have constituted a board for assessment, but the assessment, whether it will be under the 2013, my lord will have kindly see the last page of this present affidavit at 113.
Page
113, annexure 16. This is the following officers are hereby constituted as board members for verification assessment of land surface, crop tree, so and so, Dikhabale Niglok transmission comprehensive so and so for villages under New Zealand. The board so and so, so and so. Well,
Yes.
now, board may assess. The power grid, they are saying that the petitioners will be entitled for compensation under this 2013 August 2023, which talks about reserve forest. Therefore, this honorable court now has to decide whether the notification of 31 August 2023 or the notification of 29 August 2019 will be applicable to the private forest owners.
Where is that 31?
31 is at page 108, which I have
By
108.
so there's a conflicting.
This is what the power grid demands, that, okay, they will be entitled, but they will be entitled under this
Ex gratia
ex gratia
relief.
under passing to reserve forest.
They cannot decide. Decision will be state only. Are you saying that this August 31 August 23 and 29 August 2019 are
Different,
contradictory?
totally different. In fact, under this 31 August 2023, they will be getting only half the compensation. So,
equivalent half of the rates.
My submission here in the case is that the notification which was issued on 27 July 2021, each all these are confined regarding the reserve forest. Now, when I say that the preliminary notification is to be set aside, when it is set aside, there is no longer reserve forest. When the land is no longer reserve forest, in that case, the notification will also not apply, because it will be a private land. When private land, they will assess the compensation, valuation by the board, and it will be decided by the deputy commissioner. The main point is whether it is a reserve forest or not. My point is that it is no more a reserve forest. Though preliminary was notification was issued.
What about this 29 August?
29.
Like 2019.
No, that is the basis from where they are to pay the compensation.
2019.
Yeah, 2019.
Have you annexed this?
And 2000.
Have you annexed this?
No, that we were not got it. But I come to know the things from the affidavit in opposition filed by the response number 9 and 10. There I come to know. Yes, it will be applicable if the area where I am residing is become a reserve forest. Now my contention is that the preliminary notification is to be set aside because it becomes in practice. It is not enforceable. When it is not enforceable, it becomes in practice. In that case, automatically those notification issued for reserve and unreserved forest, they will not apply.
My lord, I extremely defer to the submissions made by the London Senior Counsel because
But
Supreme Court.
why the state has not been, why has been so casual?
Supreme Court.
89, you kept in abeyance. Thereafter, what you
No,
have done?
kept in evidence, still we say that it is not a reserve forest. But
Then in that case, this 1008 will not apply.
108 will not apply.
In that case, what is to be applied is?
Uh,
19
19.
notification.
19.
Is it the part of the record?
19 is not a part of record, but it has been mentioned in the
What is your stand? Your
stand of the forest department is that, my lord, since I am standing, I have to protect the interest of the forest department also, as well as the government also. Forest department says, although it is not a reserve forest, since the reservation notification proceeding has not culminated into a final notification, my lord. So it is not a reserve forest, that we admit. But the status of the land still remains a forest land because it was a forest at that point of time. So as per the definition of the forest under the Forest Conservation Act, as well as the definition given judgments pronounced by the Honorable Apex Court, even though it is a private forest, not a reserve forest, then also the status remains as a forest land. So even if one has his own land where there is forest, he will remain the owner, but that area will be considered as a forest land, for which even if that owner, private owner, if he wants to divert it for non-forestry purpose, then he will have to seek approval from the ministry. That is clear. It is not a case that the ownership will change. The forest, even if it is a private forest, then also you need to seek approval from the ministry. This is for conservation of forests. So,
yes.
So to that effect, the diversion permission has been given by the ministry through the Department of Forest, my lord, and the compensation like compensatory afforestation and all these are to be paid to the Department of Forest. But the compensation claim for the right of way of the transmission line, whether the compensation has to be paid as per the provisions of a reserve forest under 2023 notification or as per the notification of 2019. That is only to be determined, madam. The power grid says they are ready.
See,
they will.
compensation for afforestation is a different.
Thing. Different thing.
That has to be paid.
Yes. That has
And
to be
the
paid.
compensation for the landowners.
Yes.
I think it should be as per the 2019.
I believe that it is, but it is the contention of the power grid that since it is a reserve forest, since it is a forest land, it has to come under forest reserve forest. That I also differ, my lord.
This is the state is something peculiar, no? The ownership.
Otherwise, also by the various communications at page 1111 also. It has been directed.
Any assessment made by the deputy commissioner?
My lord, now the assessment process they'll have to be carried out. But board, as I have shown, board has been constituted. But this board
assessment.
Yes, but this board, whether they will follow the 2023 or the 2019.
2019. Follow that.
That has to be decided by this honorable court.
Yes. What is your claim? Under
Lordship.
2019 or
Lordship, our primary contention is that it
Land
was,
just wait, Land Acquisition Act.
Lordship. Lordship, first and foremost, the petitioner
Just
here.
wait,
Oh,
Mister,
Lordship,
just wait, we're hearing the.
Lordship.
We are avoiding other prayer. My prayer is only for setting aside the preliminary notification which was issued in 1975.
No, this has been kept evidence, why we should set aside? We cannot, the court cannot build a foundation for you. You have to establish your foundation. All right?
Since 1975 till today, after expiry of the 49 years, no final notification has.
Okay, your challenge is to that effect only, you are not claiming any compensation.
The compensation means since it is a reserve forest, both
That the
under
notification.
that's why I am
136.
challenging the reserve
Property
forest.
pursuit
When the reserve forest is out,
had no enforcement.
automatically
after
I am
the
entitled.
first period of time when it is deemed to be lapsed in effect. Under section. Shall not be set aside. Yes. Why you are saying it got lapsed? Why you are saying it got lapsed?
Yes. 1975, the preliminary notification. Until today, that is now 49 years,
Doesn't matter.
they didn't issue any final notification.
So that was, it was 89, it was kept in abeyance.
Yes, and
So under what provision it got lapsed?
leaves me, law says that as per section 70, the final notification is to be issued. And all the preliminary hearing, it should be completed within.
Which section 17?
Within three.
Which
no,
section 17?
Section 70.
Of
Section-
what?
Assam Forest.
Assam Forest Regulation.
Yes. Yes, notification declaring forest.
Yes,
reserve.
volume.
Volume 1.
Yes.
Volume 1.
Volume 1 is it.
Forest Regulation.
The period fixed under section 6 for preferring claim has elapsed. And all claims, if any, made within such period have been disposed of by the forest settlement officer. If such claim have been made, the period fixed by section 15 of the appealing from the orders passed on such a claim has elapsed, and all appeals, if any, presented within such a period have been disposed of by the appellate officer, and all land, if any, to be included in the proposed reserve forest, which the forest settlement officer has under section 11 elected to inquire under the Land Acquisition Act 1894 have become vested in the government under the act. State government may publish a notification in the official gazette specifying the limit of the forest which it is intended to reserve and declaring the same to be reserved from a date fixed by such
No,
notification.
this is regarding declaration of result.
Final notification.
By notification, it has to be declared. Where is the provision that if in case after the issuance of preliminary notification, if it is not done within certain period, or may lapse of 45 years, whatever, years,
No,
it
that
got
is,
lapsed.
yes, that
Where
is
is it?
in 6.
Hmm?
6D, fixing a period of not less than three months from the date of publication of such a proclamation, and requiring every person claiming any right or making any claim referred to or mentioned in section 5 either to present to such an officer within such period a written notice specifying or to appear before him within such period and state the nature of such a right or claim. That is in section 6 of subsection D.
3 months from the date of publication of such proclamation requiring every person claiming any right or making any claim. It doesn't say so.
Then, as per this annexure, annexure 7, it is very much clear that after issuing of this preliminary notification, the inhabitant of the Seren,
Sir, you saw us. Number one, to set aside that no preliminary notification can be issued over your land. It cannot be taken for reserve forest.
No. Preliminary notification was issued, we have no dispute. But no final notification they have not.
It has been kept in abeyance.
Indefinitely, and it affects.
What do you want to say? Well, it's up to them.
Whenever we apply for the petitioners on the.
No, first of all, we'll go to the letter. You are seeking a quashing of this preliminary notification,
Preliminary
1975.
notification.
Why?
Because
that proceeding has been kept in abeyance.
Inordinate delay. Now, I have clear. We have established here public health hospital, CHS, secondary, higher secondary school, circle headquarters. And the 7, this is circle headquarters. 7. And in the Nari.
You have established ordinance in the forest land. Reserve forest. Proposed reserve forest.
In case, see, 1975, the preliminary notification was issued. After that, government has set up so many establishments, so many departments, and even executive office of the electricity has been already set up. So, and the question that it will be remain as reserve and as forest, it always depends on the peg and circumstances of the case. Suppose a forest has been declared as reserve forest. Nobody will occupy that land. In that case, yes, once declared, it may be treated as a forest. But here in the case is that when the reserve forest was declared, that time there were so many villages. New Seren, the Telam, New Telam, and Dekapam, so many villages were already established, and it has been demonstrated whether they at that very relevant point of time, more demonstration of the preliminary notice was issued. At that time, whether there is any person who have already settled or not, it has already been demonstrated that the British officer has already clearly appointed the government in 1948 for the Seren village. It is demonstrated that the area which they are going to declare as a forest, reserve forest, that has already been occupied. Since they have already been occupied.
Entire area.
Huh?
Entire area.
Entire area.
Just occupied.
Yes, entire area has been occupied. And because of that.
Just occupied, you don't have a right.
The inquiry officer.
Just occupation would not give you a right.
Forest settlement. Before declaration of that, we have already established our ownership. Because there are 3 things.
So as the ownership.
Three things in the ownership order for acquiring of the land. First is inheritance, second is purchase, third is self-acquired in a jungle state. Because at that point, when in 1948, that time the entire area was in jungle state. Then they have set
From
up-
where you are saying? From where you are saying?
Nah,
Sir, from where you are saying?
my submission is a system.
It's a system, tradition,
System of acquiring the land.
traditional.
Traditional.
Hmm.
Three system.
Traditionally.
Traditionally. So the land was acquired by the inhabitants of them as a part of tradition. They have acquired the land by self-acquisition because the land was nobody's land. After they settled, the preliminary notification was issued. And after issuing the preliminary notification, people were not kept silent. They made a claim and objection. And because of that, the matter has been given away. Unless we make the objection, we will not make any claim.
Yes, government, what do you want to do this? Are you continue with the declaration or are you not
My lord,
interested?
the status of the forest land, even if the preliminary notification is set aside, status will remain same, my lord. It's on a forest land, my lord. Why? Because in our affidavit, my lord, I'll just to clarify why this, my lord. In our affidavit, there is
It's a
a,
question of setting aside.
yes, ma'am.
If you are not interested to pursue the.
In any case, that
You
setting
just-
aside or non-setting aside will not change the status. At page 27, my lord, or page 24, starting from page 24. At page 25, well, I'll just,
So you don't have any other grievance except this setting aside of the preliminary notification?
Yeah.
his first
In that limited context, we'll consider who is entitled for compensation and all, we're not going to say.
Yes, my lord.
All right.
In view of the meaning of the word forest in the act, it is obvious that the prior approval of the central government is required for any non-forest activity within the area of any forest in accordance with section 2 of the act. All ongoing activity within any forest in any state throughout the country without the prior approval of the central government must cease forthwith. It is therefore clear that the running of sawmill and any kind of including veneer or plywood and mining of the minerals are non-forest purposes and are therefore not permissible without prior approval of the central government. Accordingly, any such activity in prima facie is in prima facie violation of the provisions of the so and so. Then this was.
But
Huh.
in practical, in Arunachal, if you own the land, legally, whether it's forest or no forest, reserve forest, no reserve forest, comes under definition of forest. That is.
Yes, my lord.
But practically in Arunachal, once you own the land, you don't get a permission.
Practically, if it is not in the records as a forest land, it might not be a reserve forest. But if the state department has recorded it as an unclassified forest, ownership is not with the state. It might be a community forest or a private forest. Once it is recorded as a forest land, then as per the forest conservation, it is required to take permission, prior permission. In practical, that is not being taken. That is another thing. In practical, there is no because no complaints are made. But also, my lord, prior to that, my lord,
It's okay.
the definition of forest.
I've understood, but then, Mr. Pratin, when the notification has been brought, it's just a push step. Once that has been kept in abeyance and it has not been brought to logical conclusion, it has got no meaning. It has become redundant.
Yeah, that is my feeling.
So that is already there. How can we set
Yes.
aside this?
But yes, but
That will not help his case.
no. But
Even
No,
if we set
no,
aside.
his prayer is only to set aside the preliminary notification.
Because of the preliminary notification, the annexure 3 has been issued. They have shown the present area as a declared reserve forest.
No, they are admitting now, it's not a reserve forest. What they are
We are
saying is,
admitting that it's
whether
not a reserve forest.
or not, let us assuming that it's not a reserve forest.
Yes.
Because on record, this notification, the proceedings has not been completed. To declare it has to be, if it is to be a reserve forest, a notification has to be issued by declaring that has not been done. They have just
So
kept
it
in
is a
abeyance,
reserve
nothing is there.
It's
So
not a
question
reserve
of
forest.
setting aside this.
Yes, but
So what he's saying is, even if it's not a reserve forest, since has it been brought to the record of the authority or a individual ownership or community definition of the forest. Therefore, any activities diverting
now page 58.
whatever this is it on the basis of reserve forest or what?
Will not come under the reserve forest, but it was under the unclassified state forest. Well, it was a code itself. It was a proposed reserve forest. It
So
was
even
under,
if reserve forest or no reserve forest, if the forest clarification.
I'll just read out the relevant portion, my lord, at page 24, Honorable Supreme Court's judgment, where it defined forest.
It's okay, I will not go.
My lord, because my learned senior is not, I think is not understanding.
It's okay, if he doesn't know, understand, will understand, will pass the order.
It says that the Forest Conservation Act 1980 was enacted with a view to check for which ultimately results in economical imbalance, and therefore the provisions made there
Clearance, that is the
forest clearance, yes.
forest clearance.
And for 4 matters connected here must apply for forest irrespective of the nature of ownership or classification thereof. Irrespective of the nature of forest and classification
Page
thereof.
24 of affidavit.
Yes, it's a Supreme Court judgment. The forest clearance has to be obtained irrespective of the nature of class. According to its dictionary meaning, this description cover all statutory recognized forests, Forest Conservation Act. The term forest land occurring in section 2 will not only include forests as understood in dictionary sense, but also any area recorded as forest in the government record, irrespective of ownership. Irrespective of ownership.
What he's seeking is to set aside the notification.
Yes.
That on what ground it has to be set aside, that is, I'm asking him. He's not asking for any further.
His first
It
prayer
appears-
was for compensation. That's why if he's
No,
confined only.
there's no prayer for compensation.
Oh, first prayer is for compensation. He's focusing much on what the first prayer. Madam. His first prayer.
Okay.
Prayer number 1.
Issue
acquire the land and standing
acquire the
properties
land
of the
and
prisoner as per law by,
properties as per law by paying adequate compensation to the prisoner. Yes.
if he is not paying for that and only confirm to the preliminary
Are you seeking compensation also?
Huh?
Are you seeking compensation?
No, no. Compensation, we have already avoided, no?
No, you made a prayer.
Yes,
Prayer
the
one.
prayer was made for the installation of the transmission.
So that you have already received.
No, not yet received, unless it is cleared.
You are
It is
not,
not yet decided.
you are not pressing this. Prayer number 1, are you not pressing?
No, I am not pressing. Because
Prayer number 1.
yeah, prayer number 1. Yes. Yeah, this I am not pressing. Prayer number 1, I am not pressing. And prayer number
Then-
2.
Then tell me on what ground it has to be set aside.
Inordinate
Preliminary
delay.
notification.
Inordinate delay. And
Inordinate delay, why?
delay.
Is there any provision once the preliminary
Inordinate
notification,
delay for
just wait.
Now,
Once the preliminary notification is issued, if
now
we,
people are people are increasing
if we,
population.
if it is not,
Yes, we have.
brought to a, if it
Land
is,
not increasing.
sir, if it is not brought to a logical conclusion,
Yes. Yes.
what is the provision that steps and it should be,
My contention is that
are you saying that the state has the authority, I mean, declare the forest as a reserve forest? According to you, whether the state has the power and authority to declare a area as a forest reserve, a
Yes,
reserve forest,
they have.
then
After that,
whether they continue or not, it's up to them.
no. On what grounds the thing was kept in abeyance? There must be a reason. The reason was that they wanted to rehabilitate us.
Suppose today,
affected people.
today,
Affected people.
see,
were trying
today,
to rehabilitate.
yes, today, if the state want to declare it,
In the-
do you have any objection?
when an area where people are inhabited, area is declared as reserve forest. In that case, it is the duty of the authority to rehabilitate those inhabited. Those inhabited.
Where is,
If-
where is the law?
In
Where
case-
is the law?
Now,
Sir,
Now-
where is the law to rehabilitate, to declare a reserve forest? You are only entitled to have a right under the 2000 Act,
Yeah.
2016 Act.
acquire such land in the manner provided by the Land Acquisition Act 1870. That is in section 11. Section 11. Yet proceed to acquire such land in a manner provided by the Land Acquisition Act 1870. It is Assam Forest Manual.
In the case of claim to a right in or over any land other than the following rights.
Here, it is with the claimant for the surrender of the right. So there is no agreement. Exclude the land from the limit of the proposed forest or proceed to the acquire such land in the manner provided by the Land Acquisition Act, etc. For the purpose of so acquiring such land, the forest.
So will direct the respondent to follow this Assam Forest Regulation Act 1891.
Yes.
It will have a huge ramification practically.
Man, I am
You
reading.
just don't go by section 11 and 17 or
I am
6.
also reading from the
Yes.
Assam Forest.
That's why I'm saying we'll direct it to follow these provisions.
Yes.
Do you agreeable to that?
Yes.
Yes.
We'll follow this.
Will not setting aside the preliminary the notification? We'll record your submission, but then we'll direct them to follow this regulation,
Yes,
provisions of regulation.
yes. And
That's all.
claimant
That's all.
objection is heard, and because of the claimant objection, the matter was kept and opened. And it becomes inordinate delay.
So is it a ground for setting aside the preliminary notification?
Okay. That is, the ground is that they failure to make accommodation, they failure to give us a rehabilitation, because the proposal was on Gali Reserve Forest. A Gali Reserve Forest, but Gali Reserve Forest falls under Assam. And there are about the dispute between Assam and Arunachal.
That's what I'm saying. It is,
That's the ground.
it is not as simple as you are trying to project. It appears that you want to build up a foundation through this court.
No. This problem was not brought by the court. This problem is brought by the petitioner. This practically facing the problem.
Rather than doing that, rather than doing that,
Now,
you should
now-
have a solid foundation
in-
and place before this court so that we can grant you a relief.
we all do not understand the problem faced by the settlers who are in under Reserve Forest. In the rowing area, once upon a time, it was under Deopani Reserve Forest.
Yes.
They cannot get trading license. They cannot have any trading license. No, they cannot establish any investment in those areas. In the Reserve Forest area is different. It is restricted. So the people of those areas, affected areas, they are suffering.
Then who else? Anybody?
Lordship,
What do you say?
This
Yes.
Lordship. Lordship. Lordship, we are the executing agency of this project on
Yes.
behalf of DOPAP.
Hmm.
Now, Lordship, in course of such execution, the forest clearance, Lordship, which is required to be taken, we have applied and we have obtained. My counter affidavit, Lordship, page 67 is the
It's
stage
okay,
one.
okay. You make your submission. Yes.
Lordship, I'm giving my submission.
Yes.
And at page 105 is my stage 2 clearance. Now, Lordship, taking of this clearance in itself denotes that this is a forest land. The
Yes, when the state is admitting that it's not a reserve forest, how can you make a submission on that? It is a proposed reserve forest, it's not a reserve forest.
Lordship, I'm using the word forest land. That is what has been given to us.
Hmm.
Uh,
Yes.
Page 59, annexure 3.
Hmm.
If I can have your Lordship's
Yes.
attention to it.
Yes.
So, Lordship, we have paid money in crores of rupees for giving this forest clearance, where we have to forest a vast area of the land that is in a 1:2 proportion.
Obviously, it's a requirement of the law.
We have followed it, Lordship, precisely. Now, Lordship, their petition, it came with they wanted us to acquire the land. Law is settled that Power Grid does not acquire land. We are only the users on a land. We don't inculcate any other right over a land other than that of a user. The law is settled. Now, my learned senior sir here has said that he has got no, he is foregoing the compensatory matter in this particular writ petition.
Yes.
So that leaves it to the other matter being policy decision, Lordship. We as the executing agency, we do not have much say in the policy matter of the state of Arunachal Pradesh. But if the petitioners here, they are pressing for any compensatory relief, Lordship, we have objection to it. Firstly, they have come as some joint action committee. 33 of them, making one of them as the chairman of such committee. Lordship, I'm sorry to say, but there is no constitution of such committee or a resolution to the effect which is a part of the writ in itself.
Okay, we'll take it about. We'll continue the hearing on next after 2 weeks. We'll keep it part heard.
Lordship,
Alright,
Lordship, can we have it on the 21st of October if Lordship would be
not
kind enough?
21st, 25th of September.
25th,
Yes. Yes, Mr. Sir. 25th of October, September, we'll continue hearing. Sir, you clear yourself? What is the queries? You just brief him, you properly brief him. Under what? What is the rights? You are claiming that the notification has to be set aside. It's not clear. Only what he has submitted, Learned Senior Council has submitted is that since they have already settled and there was a proposal for rehabilitate the settlers, that has not been done. Therefore, and it has been kept in abeyance because of that on that ground. So now it has been lapse of more than 45 years. Therefore, it cannot be a reserve forest, right? That is what he is saying. To which this court is not that convinced. So, further, any other, I mean, which you have taken?
We have come to know that DC has already verified the land. And there's also a report that this transmission tower does not come under the notified land also. So
Notified area
yes, notified area also. So,
of the forest,
Yes,
proposed reserve forest.
yes, proposed area for also.
Okay,
So my friend, that verification report may be called from the DC.
verified.
Yes, they have already verified. Yes.
Well, let them file it if there is.
No, no, records may be called from DC.
Who has verified?
Under the chairmanship of Deputy Commissioner.
Verified the area?
Yes, verified the area and not a this transmission tower will not fall under the PRF area.
Huh?
This proposed reserve forest area.
Okay.
So it will clarify the matter.
Well, in that case, let them file it in the form of an additional affidavit.
No, we'll call the records.
Yes,
Look at the
all right.
records.
DC, which DC?
Lower Siang. the
Lower
previous-
Siang.
Yeah.
And but then the grounds you are taking, I'm not convinced. All right. You briefed the senior properly.
As per my understanding, if they proceed with this some project and we are protesting because we don't have any land, they are bound to pay us compensation as per Land Acquisition Act, as per Section 10. Now they are not proceeding that also.
Whatever next 25th September, we are hearing you again. You brief him properly. All right.
Yeah, right.
And Mr. M. Purdy, Learned Senior Counsel for the Learned Senior Assistant, Mr. K. Davi, Learned Counsel for the petitioners. And also add Mr. Anderton Swenson, Learned Edition, and D. Kamduk, Learned SC, and Mr. El Perme Swenson. Next para. Matter,
Lordship, I'm N Khera for 9 and 10.
yes, Mr.
N Khera, Nitin Khera for 9 and 10.
Nitin Khera, N.
Lordship.
Khera,
N.
N. Khera for respondent number 9 and 10.
Lordship,
Respondent number 9. We'll take it up on 25th September again.
Lordship,
We'll keep it part her.
Lordship.
No, records may be called.
Let this matter be listed on 25/09/2024 as part her list of. No, not that. No, you just delete that. Hearing could not be concluded. Audit part, huh? List the matter on so and so, 25th. On the next date, Mr. N. Ratan, London Additional Advocate General, shall produce the records with regard to the verification of the area
Unification of the area by the deputy commissioner.
by the
Lower
Deputy
Siam.
Commissioner, Lower Subansiri District, Lower Siang District.
Lower Siam.
District. We shall be apt of, what is the last? Of Lower Siang District. Just
Yes,
you
yes.
just make an
Yes, yes.
estimation and
I'll-
get it record if there's any.
Yes, ma'am. God bless.
Item number 30.
31.
So this matter may be taken up on first of today I'm exhausted, maybe.
When?
First of August, October,
1st of August,
October.
October. Counter affidavit,
We have
Everything
filed.
is-
We have filed.
Everything is over.
who has not filed counter affidavit? Respondent number 11, who is respondent number 11?
Health Department.
Copy is in, huh?
What is your claim?
No, restaurant number 11 file affidavit, but no copy was given to us.
Secretary Health in the.
Secretary Health.
Where is Mr. Tagum?
No copy was sent to us.
You are claiming what?
I'm claiming ex gratia compensation.
Huh?
Ex gratia compensation.
Ex gratia.
Yes. In respect of the, my lord, in favor of the petitioners who lost her husband, who was a member of ARBN, IRBN. And in course of performing duty.
What is the scheme?
Scheme is, my lord, 6/11/2019.
Where it is?
At page 134, Annex 6. We have also given a translated copy. Typed copy.
138.
Yes. We are covered by both A and B. Now, both covered by B.
To provide access to all those fire and emergency personnel of the state government restored rank who are killed or permanently disabled. Performing fire and emergency. B, what is the B?
Performing
A only.
A and B.
How?
Because they took the scan in their
All
affidavit
those fire and emergency services personnel of the state government.
or disaster management.
Huh?
My lord, last part, or disaster management duties. They took a decision, my lord,
No,
in their.
first you will have to be a fire and emergency services
No, while performing law and order duties under A.
to provide access to all those state police personnel, Arunachal
Yes.
Pradesh Police, Battalion and IRB rank who killed or permanently disabled or grievously injured while fighting terrorists, militants, criminals, underground elements
Or while performing.
while performing law and order disaster management
Yes.
duties in the state of.
Yes.
What is that?
Therefore, my lord, we covered by the expression
What your husband were performing?
while performing law and order duties.
What law and order?
What, my lord?
What law and order?
My lord,
What duty you were performing at the time of the death?
I was assigned with the duties, my lord, to go and collect the information in the Assam and Arunachal border.
For what?
Yes, by order dated 24 April 2020.
Where it is?
Our lordship kindly, because
COVID.
not COVID,
My lord.
not COVID duty.
COVID disaster management, it will.
During
will-
COVID period, during COVID
During COVID period.
during COVID period.
Then
During
After
COVID
that-
period. But he died not while performing duty, but while returning from duty, my lord. In an accident while returning from duty.
It is a
Basically,
settled position of
duty
law.
after the duty.
No. It is a settled position of law. Performing your duty starts from entry point and exit point. Number of decisions there.
Yeah, yes, that decisions, that is
Therefore,
only for,
performing my duties.
that is
while I-
only for to be in service, continuing in service, not performing duty.
No,
It is duty means continuing in service, for continuing in service, even going back home. for a holiday, that will also be for the purpose of being continuing in service. But this is for duty, my lord, performing of duty. He met with an accident while returning from duty.
What time?
My lord, that time
After
of
the duty hour.
No, my lord, after completion of duty.
That's why I'm asking.
Uh,
After
No,
the
no, no, no,
duty
no,
hour.
no, no, it's not correct. As per the rule, my lord, I am performing my,
The
I-
prayer of A.K. Learned Counsel A.K. Purkestal, the prayer of Mr. A.K. Learned Counsel, list this matter on 0102 010 01 110 1020 October 1st October. 1st October.
my lord, lordship, I am just surprising your lordship, my lord.
Since you are disputing the matter, I thought if you agree, we'll dispose of the matter. Yes.
They are saying discharging duty. I say while performing duty.
Okay.
And there is
Then I
a,
will consider.
God bless you.
Yes.
Matter pertaining to compensation from this.
Yeah.
Power Grid Corporation Limited. Now, what happened, this Power Grid Corporation is constructing one tower, this 132 kV transmission tower above the hilltop of my house.
Who is not paying? Power grid.
Yes, Power Grid.
Ah,
Basically, my claim is
which
against.
for the power grid?
Lordship, I'm representing Power Grid.
Yes. Why? You have asked for the assessment.
Lordship, absolutely, we had asked. Lordship, there has been some development. Lordship can reflect order dated 7/6/2024 also. We had seek leave and we were granted leave to file an additional affidavit. Lordship, what we have learned, Lordship, firstly, in our affidavit, in our counter affidavit itself, we have raised a ground that there was some force and duress which was put on our officials for certain communications which we were not willing and ready to do it. That being said, Lordship, in the meantime, what we have learned is that compensation has already been paid to the petitioner herein by the state authorities for this said natural disaster which had taken place. So now they are trying to take double compensation, Lordship, for the same issue. And it is
But then,
public.
see, on your own asking, the deputy commissioner has assessed the damage.
Lordship.
Whether they gets any compensation from the state or not doesn't make it. What is your concern?
Lordship, we were not aware that they have been paid the compensation. That is the reason why we went ahead with the assessment and all.
What is the stand of this deputy commissioner?
Lordship, state has not filed an affidavit. If state files an affidavit,
But can you see the letter, your lordship, page 35? Letter of the DC to the Chief General Magistrate.
35. Yes.
Okay, may I read?
Yes.
With reference to the subject cited above, I am to inform you that the house of Shri Tarha Taju, Holongi village was reportedly damaged due to landslide occurred in the month of June 2022. Accordingly, as per the government norms, immediate relief assistance was paid to the victims in the presence of ADC Balijan and more others. Moreover, as per the government norms, the final relief assistance was also paid to Shri Tarhu Taju through PFMS mode after duly recommended by District Executive Committee. As per the rules of state government of Arunachal Pradesh, relief assistance has been paid to the victims, and further it is requested if there is any provision for payment of compensation or guidelines exist, then the same may please be considered at your end. This is for your kind information, necessary action, please. Relief assistance only, your lordship, has been paid to the petitioner, your lordship, by the district administration.
It's an immediate relief.
Lordship.
Yes, immediate relief the state has paid.
Lordship.
But the compensation for damages, which has been assessed by the district authority.
Lordship, for the damages also in their writ, they have said that the assessment should be done in terms of Section 10D of the Telegraph Act. Now, if the
You come to your letter, page 36.
36.
Lordship.
Come to your letter.
Lordship. Lordship.
Yes.
Lordship, we are not denying or disputing these letters. However, Lordship, there is a clear averment in our counter affidavit itself, Lordship. We were put under some stress and duress to issue certain letters from the side of the petitioner.
This is unheard of. This is unbelievable.
And after that, bank account also has been.
Can you write a letter to the additional deputy commissioner, and can they make an assessment under duress?
Lordship,
And then this additional deputy commissioner, page 37, has provided you the bank account.
Bank account also, Lordship.
Lordship,
And
we are
this-
not denying any of these letters, Lordship.
We're granting you 2 weeks time.
Lordship,
Make the
Lordship,
payment.
Lordship, I may be heard in physical on 25th. I will impress Lordship may pass the said order on 25th if required.
We're fixing it on 25th.
Lordship,
Tell your client, the
Lordship,
respondents, Power Grid,
Lordship,
ready for the payment. This is not done.
Lordship, and I may be allowed to exercise my right as I.
Definitely we'll hear you, but then on next date, we're expecting that you'll come up with a proposal to deposit, that you have deposited.
Lordship,
Talk
and
to
Lordship,
your client.
I will, Lordship, Lordship, I may be allowed to file an additional affidavit if required before 25th.
Convey the tentative view of this court
Lordship,
to
And-
the authority,
Lordship,
Power Grid authority.
I
You
will.
cannot play like this. All right.
Lordship.
Whatever
Lordship.
you want to file, you file. We are not passing any order. All right.
Lordship,
On the prayer of heard Mr. So-and-so, learned counsel, KW, learned counsel for the petitioner, and also
I'm for respondent number 3.
which more one? Mr. L. Perme for respondent, learned standing counsel for respondent, and MS. Not comma, huh? MS R. Basar, learned state counsel for respondent number 3. And who else? And
Lordship,
Mr.
N. Khera.
Nitin
Khera,
N.
Lordship.
N. Khera for respondent number.
Lordship, I am for respondent number 2, Lordship. Respondent number 2.
Then you serially write chronologically 1, 2, 3. Huh? Next matter. On the prayer of Mr. N. Khera, list this matter for hearing on 25/09/2020. 2024. Christopher, on which date? No, it's okay, 2024. Yes, you appraise your authority. The view of this
Lordship,
court, you will have to
I will.
pay.
Lordship,
Nothing
the date fixed is, Lordship,
25th.
25th. Lordship. Highly obliged, Lordship.
I beg to mention for tomorrow, my lord.
Yes,
I beg to mention for tomorrow, my lord. To be listed tomorrow, my lord. With petition number.
it's not the right time. Make a mention tomorrow.